seated again, yeah. Good afternoon. Welcome to the Appellate Division First Department. Today we have more than 7.5 hours of argument time requested. As you can imagine, we're not going to be able to quite meet that number. I want everyone to be assured, we have read your briefs. We have read the record. We are ready with questions. So please, when I call your case, please stand up and give me just the amount of time you think you need to make your most salient points. And for anybody who hasn't been here before, if the light is white on the podium there, that means you have 2 minutes left to argue. If the white is red, your argument time is done. And I'm going to ask you, please, when the red light comes on, to end your argument so that I don't have to end it for you. Okay? All right. People versus Jamel Richardson, submitted. Abramovich versus Deutsche Bank Securities. So, yeah, how much time? 15 minutes, please. Oh. Okay, so obviously, again, if we can't give everybody 10 to 15, do you want reply time?
I'd like to do it 1 minute.
All right, so what I'm going to do is give you 6 minutes and one on reply, and I'm going to give you 6 minutes for your argument too. W. Children, submitted. Urban versus Zipper.
For the appellate, I would withdraw. 7 to 10 minutes, Judge.
And do you want any reply time?
2 minutes.
Okay. Okay, I'm going to give you 6 minutes and 2 minutes on reply and 6 minutes. People versus William Huggs, submitted. People versus Reginald Banks. Okay, how come you're all the way over there? You didn't get in time? Okay, 4 and 1, yes? Okay, 4, 1, and 4. Metropolitan Partners versus Nerie. All right, so I'm going to give you 6 and 2 and 4 and 4. Okay? Attorney General of the State of New York versus Kenny S. All right, I'm going to give you 7 and 2 and 7. Goodman versus Stack. You don't have anyone to argue against you. It's probably not good to argue against yourself. Do you want to get the motion, the appeal submitted? Sure. Okay. Thank you. People versus Ricky Moore.
Justin Bonus on behalf of Appellant Ricky Moore, 10 minutes, Your Honor.
The people request 6 minutes, Your Honor.
All right, I'm going to give you 5 and no, I'll give you 1 in reply and
7, I guess, and 3, Your Honor.
I know what you asked for. I have pretty good hearing. I'm going to give you 5 and 1, and I'll give you 5, okay? Pizzarati LLC versus MDB Development, submitted. W. Mary versus Robert W., submitted. People versus Tony Manley.
Appellant requests 6 minutes, Your Honor, reserving 1 for rebuttal.
All right, I'll give you 5, 1, and 5. Trinity Center versus Subway Real Estate.
Yes, good afternoon.
6 and 2, and 6, 2, and 6, yes. Sutherland versus Tavern.
Good afternoon, Your Honor. Emma Wigan from Respondent is Appellate is not appearing all to be on submission.
Great, thank you. People versus Sharhonda Hart.
Good afternoon, Victoria from the Office of the Appellate Defender. First, I'd like to ask for this court's permission to allow one of counsel for this Benzie of the Bar of Pennsylvania to participate in this.
Welcome, and yes, your application is granted. How much time would you like, counsel?
7 to 2, please.
People request 7.
All right, I'm going to give you 6, 2, and 6. You can see where I'm headed with these numbers, right? Okay. People versus Joseph Evans, submitted. People versus, will of Michael Milbound.
Joseph Bruner, the respondent for the appellant, and 5 and 2.
Judge Angelo Grasso, the respondent,
5, 2, and 5. Baxter versus Ghosh, submitted. People versus Vamula Patti.
People request 5, Your Honor.
5, 1, and 5. And then we have Servan versus ES Builders Group, submitted. Distal versus Distal, submitted. Harge versus Honorable Lewis, submitted. Okay, that's the end of the calendar. So please, our first argument, Abramovich versus Deutsche Bank, come up, please. Ready, counsel?
Good afternoon. I may please the court. My name is Andrew Goodstadt from Goodstadt Law Group, PLLC, on behalf of the plaintiff appellant Neil Abramovich. Your Honors, the trial court below erred in granting summary judgment on collateral estoppel grounds for at least 3 reasons. The first reason is the issues addressed by the federal court under Title VII of the New York State Human Rights Law were not identical to the ones at issue in the case here under the broader New York City Human Rights Law retaliation standard. And they were not, quote, necessarily decided or, quote, actually litigated and decided as required to apply collateral estoppel. Indeed, Judge Caproni in the federal court explicitly disclaimed engaging in the, quote, separate and, quote, independent analysis required under the New York City.
Why wouldn't the Russell case, which is fairly identical with the exception of the fact pattern, but the same procedural posture, be controlling here? Because the sole issue, as I see it, is temporal proximity.
I apologize, I didn't hear which.
I said the sole issue is really temporal proximity because, as Judge Caproni found and the circuit court affirmed, your client was unable to submit any evidence to create an issue of fact as to the legitimate reasons for why he was terminated.
Correct, Your Honor. The judge below did determine that that Mr. Abramovich could not meet that standard under a pretext standard, which is the but-for standard under Title VII and at the time, the New York State Human Rights Law.
The evidence of his diminished earnings was rather compelling, wasn't it? I mean, it wasn't like a small diminishment, but there was a major drop in the monies that he was earning for the firm. Is that correct?
Well, his earnings that year were diminished, correct. However, that fact could be true, as well as the decision to give him a 0 bonus and eventually terminate him could also be motivated, at least in part, by retaliatory animus.
Except the Second Circuit said no. The Second Circuit looked at those facts specifically, and I can read you from the Second Circuit decision, where they said specifically that those facts don't raise an issue of fact as to retaliation. That is a factual finding that we have to give collateral estoppel to. Is there any fact that you think that you raised that the Second Circuit or Judge Caproni didn't deal with?
Well, Your Honor, it's not the question of whether the facts were decided. It was the analysis under a much stricter standard.
Collateral estoppel doesn't gives you, you have to accept the factual findings of the other court. So this, Judge Caproni and the Second Circuit made factual findings. It was a motion for summary judgment, not a motion to dismiss. So again, I'm going to ask you, what facts do you think were not found or not discussed in either the district court or the Court of Appeals, the Second Circuit, that you're raising here in this court that that we should send for a trial?
Your Honor, we respectfully submit that there were at least five facts actually found by Judge Caproni that can satisfy the lower mixed motive standard that the court and the Second Circuit held didn't rise to the level of showing pretext. First, under the New York City human rights law, the standard is whether retaliation played any role in the decision. And that can be demonstrated by, quote, either directly through evidence of retaliatory animus, such as verbal or written comments, or indirectly by showing that the employer's action closely followed in time the protected activity or that similarly situated persons were treated differently.
So, counsel, we would agree that in federal court, there was a determination that your client established a prima facie case of retaliation, yes?
Yes.
And the issue here, as we all agree, is the issue of temporal proximity, correct?
Well, it's not just temporal proximity. There are a number of factors. There are at least five facts that I can go through with the court that would be able to satisfy the lower burden under the New York City human rights law. First, there's actually direct evidence of retaliatory animus. One of the decision makers in the case, a gentleman named John Eidenberg, actually threatened Mr. Abramovich's business partner, who also participated in the exact same investigation, and said, quote, "You should assume I know everything," and what was said during the investigation, right before he told Mr. Mortara that he would not get the bigger role that he applied to, just like Mr. Abramovich.
So how do you deal with the Second Circuit saying, for most of the adverse actions, Abramovich provides no evidence of pretext other than temporal proximity between the protected activity and the adverse action? That is a finding that we have to give collateral estoppel effect to.
I understand that, Your Honor, but pretext is not the standard under New York City human rights law. You can get past summary judgment by showing either pretext or that the adverse actions were motivated, at least in part, by retaliatory animus. Your Honor, I see my time is up, but
You have time on reply, right?
I do have 1 minute on
Okay.
reply.
Thanks.
Good afternoon. Cameron Smith on behalf of the defendants, respondents. The issues in the federal...
So, counsel, I'm going to jump in.
Sure.
Okay. Are you familiar with Hamburg?
Amber?
Yeah.
I
The
don't
First
remember
Department,
that case.
2017, where we said discrimination was one of the motivating factors for the defendant's conduct. That's where we held that plaintiff defeated the defense of the defense by proffering temporal proximity as evidence to establish that discrimination was one of the motivating factors for the defendant's conduct. So here, where the federal court held, we have long held that temporal proximity between a protected complaint and an adverse employment action is insufficient to satisfy plaintiff's burden to bring forward some evidence of pretext. Would you agree that the federal court used a different lens to analyze the facts in this case?
I think the federal court recognized that there was a different standard of but-for causation within the McDonnell-Douglas burden-shifting framework for
Can you talk louder?
for Title VII claims. But that is not relevant to the court's analysis here because the federal court found that there was no pretext, that none of defendants' reasons were pretextual. And although my worthy opponent says that the New York City human rights law does not require a finding of pretext, I respectfully disagree. I think that his own briefing points to cases where there is a burden-shifting framework in analyzing a New York City human rights law claim. Judge Caproni has already found that defendants' reasons were not pretextual. Now, plaintiff could try to defeat a finding or a legitimate reason proffered by the defense using a mixed motive framework on a city law claim, which obviously wouldn't work on a federal Title VII claim where you need to use but-for causation. But Judge Caproni's finding that not just defendants' reasons were legitimate, but in fact they were non-pretextual, and more, that plaintiff hadn't provided any evidence of a motive. And Justice Scarpullo, to your question, I don't think
wasn't there evidence of motive in that the dismissal was because of retaliation for having testified against a person who was in favor with some decision makers?
Well, I think that's exactly why collateral estoppel should apply here, because plaintiff can't escape the fact that Judge Caproni found that there was no history of protection of Jason Grandiano. And in fact, the argument plaintiff advanced in the federal court that Eidenberg, Hantho, and Bunzel were motivated to protect Grandiano was illogical and was unsupported by the evidence.
And sir, would you agree that while we acknowledge that the city human rights law has a broader prism with the mixed motive analysis, we all acknowledge that, we still need evidence, facts, to show that there was some kind of pretext? And it's clear, based on the district court's finding that you've referred to, as well as the Second Circuit affirming the district court, that they didn't meet their burden either under the but-for standard or under the mixed motive standard.
Absolutely, because despite its broader construction, the city human rights law still requires a finding of pretext. And then a plaintiff can establish causation on a mixed motive theory, doesn't need to do so on a but-for causation theory, but still there's been a finding that none of the reasons proffered by the defendants were pretextual. But Judge Caproni didn't stop there. She also analyzed plaintiffs' proffered retaliatory motives and found that there was no retaliatory animus that could be supported by the argument that these people were friends or had shared Canadian roots or that there was a history of protection. And so I think this is exactly the kind of case that collateral estoppel is designed to protect against an issue being litigated more than once.
And I think our Court of Appeals very recently in Russell made it clear that we cannot ignore those federal findings, that we have to apply them here.
Yes, and I think that plaintiff can't escape these findings that, for example, the bonus decision occurred before defendants learned Abramovich had complained of retaliation, that Hackle's move to ECM couldn't be retaliatory, that Abramovich has presented no evidence to contradict Hantho's testimony regarding the bonus decision. I mean, I could go on.
And he wasn't the only one that didn't receive a bonus.
Exactly, right. And I think that Abramovich has tried to point to or argue that the explanations around the bonus decision and Irwin's directive were inconsistent or contradictory, but Judge Caproni has already found that they are not. And so to the second point—
So, counsel, in your view, the fact that there was the elimination of his department and that he like others, like two others, I believe, was terminated, and his bonus was denied because of reduced expectations, you're saying that those elements are dispositive here?
I'm saying that Judge Caproni's findings that the defense's explanations for those decisions were non-pretextual and that plaintiff didn't articulate any retaliatory motive to contradict that finding is dispositive of his city human rights law claim, even though the standard is broader. That doesn't negate the preclusive effect of the federal decision.
Okay, thank you, counsel.
Thank you.
Thank you, Your Honors. I just wanted to.
Counsel, would you agree or disagree that if the sole issue was temporal proximity, you've mentioned other factors, but let's assume for the purpose of discussion, the sole issue was temporal proximity, would that be enough to get this to a jury trial under Russell?
I believe under the mixed motive standard, temporal proximity plus would get you to a jury. And I believe that there are cases, and we cite them in our brief, that the friendship between the decision makers and Mr. Abramovich would be a plus. I mean, the case that we cited in our brief, the case we cited in our brief, Alfano versus Starbucks Corp., under the New York City human rights law, if a plaintiff shows close temporal proximity between protected conduct and termination and was treated differently than similarly situated employees, that's enough. And I think that Mr. Abramovich was treated differently than many similarly situated employees. In fact, the other employees who received zero bonuses, Judge Caproni specifically said they were not similarly situated to Mr. Abramovich. So they're not comparators. There wasn't a single other managing director in New York that received a zero bonus. Only
Okay,
Mr. Abramovich
counsel.
and only Mr. Mortar was slated to, and he was the one who also participated.
Thank you. Urban versus Zipper? Go ahead, counsel. May I ask you to go up to the podium and speak into the microphone?
Absolutely. This is a case that is as clear as it gets.
Counsel, could you make your notice of appearance, please?
Yes. For the appellant, Ryan Urban, Altagracia, BPO Outerbridge of Outerbridge Law, 1460 Broadway, Suite 12018, New York, 136. Dear Honorable Court, this is an issue that is as clear as it gets. It regards the issue of a security deposit in the amount of $70,000, wherein when the appellant vacated, the strict deadline of a 14...
So let's start with that. What's your position? When did the appellant vacate?
September 1, Your Honor.
September 1?
Correct.
Is that, are you sure? That's your
Yes.
position?
That is our position.
Is there evidence that would raise an issue as to whether he actually
Yes, and I'm going to
vacated?
address that, Your Honor.
Okay,
Your
let's
posi-
hear it, yeah. That's really quite, the real issue here is, everyone agreed that in October there was a accounting of the 70,000. Your position is it didn't meet the 14-day period because he didn't vacate, and it is the landlord's position that it did meet that deadline because he didn't vacate, right?
Correct.
So tell me, why do you think what evidence do you have that he vacated on September 1?
Absolutely, Your Honor. The actual surrender from my client's agent saying we have left. The issue that is before...
Did your client put in an affidavit saying, I left and took out all my stuff and left the apartment, the house, I guess, or the townhouse, broom clean on September 1?
Your Honor, whether or not he left an affidavit, what is
I'm just asking you, let's start with, did your client do that?
The motion itself talks about it, and the
I'm
brief-
asking you, I know the answer, so did your client put in that affidavit?
No, the issue is I don't remember. That's what I'm trying to say.
okay.
I'm not trying to evade the
Okay.
question.
What is
Counsel,
also-
wasn't there, I'm sorry.
Sorry.
Go ahead, Marty, go.
What is, 9B of the lease makes it clear that if the tenant left any property at the premises, then it is deemed as if that tenant did not vacate. So let's understand this record. Allegedly, as you claim, there was a move out on September 1. But then there seemed to be an issue as to whether it really may have occurred on September 17th. And then we have this issue of the mailbox key. And against that whole backdrop, we have is it a hot tub?
Hot tub.
Among other things, that was on the roof that was never removed from the premises. I'm not even talking about the actual damages there. So would you not agree that the existence of various property of your client would trigger 9B and perhaps at least raise an issue as to whether there was a total surrender on September 1?
I would not, Your Honor. The issue, there are many things happening here. One is the lease itself provides for the remedy for items left behind. It is deemed abandoned, right? So the landlord cannot.
Does the landlord have to treat it as abandoned, or does he have the option under 9B to consider it as if the tenant is still there?
So then, Judge, you're going into another issue, which is the inspection didn't take place as it was supposed to. The point of the inspection when the tenant says, I'm leaving, is that the landlord comes in and says, you better take this out or else I'm going to deem that you didn't vacate timely. That was exactly the point of the inspection. So they failed in two pieces. So whether the landlord did not do it, it's undisputed the inspection did not take place despite proper notice.
Counsel, but the lease doesn't call for the inspection. It clearly says if your property remains in the apartment after the lease ends, owner may either treat you as you're still in occupancy or charge you for use. And allegedly he left a hot tub, air mattresses, bed linen, camera equipment.
Correct, Your Honor.
So it doesn't say anything about an inspection. It says, I'm putting you on notice that if you move out, you need to take all your stuff with you, or I can consider that you're still living there.
Except, Your Honor, the statute says anything against this. You're talking about a remedial statute that is very clear. It's a shall statute. It says anything that tries to contradict the statute is void. That's exactly what's happening here, contradicting the statute. Even if Your Honor were correct, right, which respectfully, Your Honor, may be.
Wait a second, you are saying that anytime I can just walk out on September 1, leave all my clothes, to keep my keys, but I say I walked out and that's enough?
Your Honor,
After
that's the
signing a
point of
lease that says this.
That's the point of the inspection. This
Oh,
is
I
a
don't think that's
two-part.
correct.
Okay, fair,
But,
Your
okay.
Honor. So
And
then,
let me just say that
I wanted to add one more thing.
your client submitted an affidavit that he surrendered on September 7th. You're up here saying he surrendered September 1. Already, I say to myself, you're saying something different than your
immaterial,
client.
Your Honor, this is a 2-year-old case. I'm getting older, right? That's immaterial. That's after giving birth, it's all gone. But that's immaterial. Whether it's September 1 or September 7, the 14-day, this is as strict, this is why I love this statute. It's as strict as it gets. It's a shall. Anything otherwise is void. So then the landlord can, I've been doing landlord-tenant exclusive for 16 years. The landlord can find any excuse to say, hey, you are still here. To this date, he could say he's still here. When did he exercise the remedy that he wasn't there anymore, right? That is conveniently as soon as the deadline has to meet that.
No, all your client has to do is take his stuff, and then the statute starts running. It's very clear and very easy. There's no landlord gotcha here. Your client clears everything out and leaves, and then the statute starts. But there is a question as to whether or not. Do you deny that he didn't take out the hot tub on the roof?
Well, this is what discovery will find is damages, right? This is the issue. So
I'm asking you whether you are denying that when he says he left a hot tub on the roof.
I am, because we've
denying
had
that he did that?
depositions wherein my client says this hot tub was yours. You put it in. So then we have issues with that. The issue, there's a two-prong to the statute, Your Honor, to avoid this gotcha, right? Which is, I'm telling you I'm leaving. Therefore, you come and you inspect and you say, you better do A through Z, otherwise I'm gonna take your security. They failed in both prongs, and both a failure on either prong leads to give me back my security.
Okay, thank you.
Okay.
You have time on reply. Counsel?
Good afternoon, Your Honors. Brian Hoffman from Prior Cashman.
Why don't you address the issue of the inspection first? Because counsel is saying you never inspected and gave a list of things that have to go out, and therefore my day of September 1st or September 7th, whatever day, is more than the 14 days, is what we have to deal with.
Sure, Your Honor. An inspection is only triggered if Mr. Urban had vacated the apartment. Mr. Urban did not vacate the apartment, and the lease permitted my client to treat Mr. Urban as still in occupancy.
So counsel is arguing that that is a fortiori unenforceable.
It's not unenforceable under the statute, Your Honor. The statute provides that any provision of a lease that waives or modifies a tenant's right is void. Let me give you an example. If the lease here said, tenant is absolutely not entitled to an itemized list within 14 days, that would be a provision that would waive or modify his rights. I want to
Or maybe say, no, give me 3 months, and then.
Sure. I
something
also
like
want to point to one other thing at page 31 of the record. This lease that was signed by my client and Mr. Urban is the standard form of apartment lease by the Real Estate Board of New York, Inc. This is a standard lease with standard terms that Mr. Urban, who the trial court called a sophisticated client, agreed to. And I'd also like to make the court aware, take judicial notice of the fact that in 2019, after this lease was signed, the Real Estate Board amended the standard lease. The same provision is still in there. It's active today. That's publicly available.
So, counsel, to your knowledge, is there any statute or rent regulation which arguably doesn't apply to this particular 6-month lease at the monthly rent that it was leased? Is there anything that would bar a lease from saying you either take all your things out or we can opt to continue in occupancy?
Not that I'm aware of, Your Honor. Nothing that I'm aware of. I think there's, of course, some sort of good faith and fair dealing in any contract, and this is a contract, where, if Mr. Urban by mistake left his hat on the kitchen table, then my client would not be, in his right mind under the terms of the lease to say you didn't vacate. But that's not what happened here. We had a hot tub on the roof.
And then would that be rent or use and occupancy? With the lease, this is a 6-month lease.
Sure.
So to the extent that there was no vacatur as deemed by the owner, would the dollars owed after that be rent or use and occupancy? Or does it make a difference? Is there a distinction without a difference?
I think it's a distinction without a difference, and Your Honor, there was no rent due after this time.
Today, your adversary says that the hot tub was yours.
That's not true.
Well,
it's not in the record, but it's not true.
on this record, as I understand it, it's almost $250,000 worth of damages.
More, Your Honor, but yes.
If not more. And the sole issue really is when did that 14-day run? Isn't that what it's all about? So they claim we were out on September 1. No dispute that there was personality or property there in the apartment, which means under the interpretation of 9B, they're still in occupancy. And you could say that you timely served them an itemized statement on October 1st, correct?
Correct. And we did timely serve it in the sense that he never vacated the apartment. So we provided that to him well within our time. There was, again, a hot tub on the roof. That is not Mr. Urban removing his property from the apartment.
Where did the leaks emanate from, or is that not part of the record?
I'm sorry?
Where did the leaks that damaged the building emanate from, or is that not part of the record?
It's not part of the record, Your Honor. I can go into my understanding of it, but that's, to my knowledge, not part of this record.
The leaks, though, went beyond one floor of
Yes.
the building?
Yes, Your Honor. Second and third floor severely damaged by the leaks that Mr. Urban caused or allowed to be caused.
And how many floors in this building?
My understanding is it's 3 plus the roof.
3 plus the roof.
So let me ask you one last question. Your client put in an affidavit, I guess, Brown, that says that
Mr. Brown is not our client,
Landlord's
just to be
assistant.
clear.
The landlord's
Correct. He's my client's, he works for him.
Right, okay. So your client being in the we and general sense. Mr. Brown puts in an affidavit that says, the landlord's real estate agent, the tenant moved out of the premises on September 16th. If that is true, then would the October 1st date be timely?
Your Honor, I'm not going to be intellectually dishonest. If that
That would
was,
be a one-day difference, right?
it would be a one-day difference.
A lot of different things going on
It would be a one-day
here.
difference only if that was the day that he actually moved out. That was not the day that he moved out under the terms of the lease. It's the day that we understood he left the apartment, but he never actually vacated under the terms of the lease.
So the
He didn't
tenant has
return the mailbox key.
Right.
Correct.
Till September 30th.
The record is unclear on that. My
That's what
understanding is
Brown says in there.
there was a request for it on September 30th, and my understanding is it was never returned.
The key was never returned?
As far as this record is concerned, that's my understanding.
Okay, all right, thanks, counsel. Counsel?
All right, if we're talking about intellectual honesty, this is an agent saying these people moved out 9/16.
No, that's the agent saying that you said that the client moved out on the 16th. So now we have 3 dates.
right.
Today you said the 1st. Your client puts in an affidavit that says the 7th. The landlord's assistant said that you said the 16th. So it's really unclear to me how we could issue a summary judgment decision when you yourself have 3 different dates of when you think you moved out.
Your Honor, our position remains, if it were 16th or 7th on the 1st, either way, we can move back into the inspection never happened. It is undisputed that notice was given. I can read the statute to the court.
Counsel, when was the mailbox key returned?
I don't know, Your Honor.
Isn't that a
but
problem with respect to a motion for summary judgment where surrender is an issue?
No, Your Honor, because the statute says that would be voiding the statute to this. So let's talk about it. Then he would be charged rent. Why is there no rent charge? This is a fabricated story to get around.
Counsel, when you vacate a rental, you don't give back the keys?
Some keys are very much lost, Your Honor. So this is part of the inspection.
Is there anything in the record that says that the key was lost?
No, Your Honor, but it's
So
not.
then we can't speculate, right?
Absolutely. Okay, so then let's talk about the inspection. That is undisputed. The point of the inspection is to avoid this dispute. I'm coming in, you're saying you're leaving, I can read the statute at Part B, right? If I give you notice within a reasonable time after notification of either party's intent to terminate, unless the tenant terminates with less than 2 weeks, did not happen.
Did your client submit an affidavit that says that he moved out mid-September?
That is undisputed. There's no need
No,
to
is
sub-
that a yes?
That is a no, or I don't remember, but it's things that are undisputed, Your Honor, don't need an affidavit because we could have
But
an
the date is disputed. September 1st, September 17th, September 7th.
Not to the extent that there was no inspection, Your Honor. No inspection occurred.
Okay, thank you, counsel. People versus William Hooks.
Submit.
It's submitted.
Oh.
Oh, it is submitted.
Oh, it is?
Reginald Banks.
Yeah. Oh, right, okay. People versus Reginald Banks.
Good afternoon, Your Honor. I may please the court. Jessie Hussey by the Legal Aid Society on behalf of appellant Mr. Reginald Banks. Mr. Banks is here today merely to request the court shorten his sentence to the statutory minimum. He was convicted of a felony for the first time. All the other crimes that he's been convicted of before are small violations.
He
Counsel,
pled
wait.
guilty to attempted murder in the
Correct, Your
second
Honor.
degrees, right? And he shot 2 people, correct?
Correct, Your Honor.
And he got 6 years.
Correct, Your Honor.
And he waived his right to appeal.
I will get to that, Your Honor. But yes,
Well, why don't you start with the waiver? Because obviously, if he waived his right to appeal validly, then you don't have any argument.
correct, Your Honor.
Okay.
So turning to the waiver, I think there are two main issues. With respect to the colloquy, the way that the court phrased Mr. Banks's, at least the rights that he would be giving up, is that the court framed it in the context of a trial. So the court said, had you gone to trial, you may have taken things to an appeal. The scope of issues that would come out of a trial for appeal and for a plea are very different. And given that this is Mr. Banks's first felony, it's likely that he doesn't have a lot of experience with waiver colloquies in the past. And then the court also carved out issues that the waiver did not apply to, right? And the similar thing was done in the written waiver.
There's also a written waiver. Is
Yes.
there anything that was wrong in the written waiver?
Your Honor, it isn't necessarily the language of the written waiver that we're taking issue with. We're taking issue with the fact that the court didn't verify with Mr. Banks that he read and understood the waiver that he did sign. And we cite a few cases that say that the written waiver cannot cure the colloquy when
Okay, but the lower court thoroughly explained the nature of his right to appeal, noted that it was a separate and distinct from appellant's trial rights, that he was automatically given up. He detailed what appellate rights would be waived and what ones would survive, and made sure that the appellant went over the written appeal waiver with his attorney. I don't see how this waiver was invalid.
Your Honor, there are a couple issues there. Making the trial rights distinct from the appellate rights is the beginning of a good colloquy. It is not the end of it. Trial rights and appellate rights are distinct.
What did the court miss?
I think the court, with respect to the written waiver, Your Honor, the court missed asking Mr. Banks if he had actually read and understood the waiver that he did sign.
But wasn't there an understanding that he conferred with counsel? Isn't that on the record?
Yes, Your Honor, that's on the record. But
What could they have been doing? I mean, they're together, they're looking at the waiver together, they're going over the waiver together. What else could they be doing?
making a record, Your Honor. It was the court's responsibility.
They made a record, the court made a record that he was there with his client, the lawyer, going over the waiver, correct?
Correct.
So you're saying, and then at the end of that, he had to again ask, did you go over this with your lawyer? He made a record about that.
No, Your Honor, I'm not saying that the court
And have
should
we ever held that if that was insufficient before?
No.
I think, Your Honor, we cite the cases including People v. Thomas, People v. Lemon, and People v. Outley that say that written waivers cannot cure
I
the
understand.
colloquy.
I'm asking you a different question. Have we ever held that a court who says on the record, you are going over this with your lawyer, do you have any questions? And the answer is no. Have we ever held that the court then separately has to say, and by the by, do you understand the waiver? Have we ever held that before?
I don't believe the court has exactly held up.
Has any court ever held that before in any department?
Not to my knowledge, Your Honor.
Okay, so let's assume, what else about the waiver do you think is invalid? Let's assume that that's one thing. You said there were a couple of things.
No, Your Honor, I think that is the main issue with
Okay,
the
but
written
what?
waiver.
Okay, so the main issue that no court has ever held to. But let's ask about any other issues that you have with the waiver.
I think the understanding of, I say my time is up, can I?
So just make 1 minute of argument about why you want a second-degree attempted murder charge with 6 years to be reduced.
Your Honor, I understand that Your Honor is saying that my client got the benefit of the
It's a great deal. I don't think you would argue that.
Including, there was footage of the shooting, and he
understand.
got 6.
I understand, Your Honor. I'm not trying in any way to minimize his responsibility. I just want to bring the attention of the court that he's a father of 3. This is his first felony. And it's simply a question of bringing it down to the minimum from 6 to 5 and the PRS from 5 to 2.5. Thank you.
Thank you. Counsel?
Good afternoon, ADA Mallory Phelps to the people. The written waiver in this case forecloses review. The judge not only clearly described the trial rights and the appeal rights and how those rights were separate, but she asked if defendant understood these rights, which he confirmed he did. She then saw him and his lawyer read the written waiver in front of her in court, and then asked him if he had any questions, and he confirmed that he did not. Further, this sentence is not excessive. As Your Honors have already stated, this is a very serious crime. He opened fire in a public street. He hit one victim multiple times and hit a bystander and risked everyone in the public street and their safety.
He got 1 year above the statutory minimum and 19 years below the maximum, correct?
Correct. And this sentence, there was 2 victims, and they were not concurrent. Further, he discharged multiple felonies that he was originally charged with in the indictment and was only charged with 1 felony for this very serious crime.
At the time the plea was made, everyone understood that this was his first felony, correct?
Correct.
And everyone understood his age and the mitigating factors that would obviously lead a much larger sentence to a 6-year sentence.
Correct, and that can explain why he got such a good deal.
Yeah, I'd like to know.
Yes, all the factors that defendant brings up on appeal were known to the sentencing court at the time of sentencing. If there are no further questions, we rest on our brief. Thank you.
Thank you.
Your Honors, just briefly, the only point I want to make is with respect to the facts being already before the trial court, it is the interest of justice jurisdiction of this court that allows it to look at those facts anew, and that's all we're asking for today.
Right. I mean, is there anything that you think that the trial court didn't look at?
Your Honor, the record is limited. It's hard for me to respond in a negative. It's merely a question of this panel looking at the facts anew in light of the argument that I've made today and making its decision.
There was a pre-sentence report, correct?
Correct, Your Honor.
And that pre-sentence report was given to the judge?
Correct, Your Honor.
And that report had the mitigating evidence in it that you're discussing now?
Correct.
Okay.
But, Your Honor,
I'm just curious as to whether there's, yes, we obviously will review again, always. But I was just asking you whether you thought there was something that was missed in the pre-sentence report.
no, Your Honor, I would have mentioned it, but no.
Okay.
Thank you.
Thank you. Metropolitan Partners versus Nerie.
Good afternoon, Your Honors. May it please the Court, Michael Richter on behalf of defendants appellants Brian Nerie and David Horton. Your Honors, this appeal raises some very profound issues regarding the sanctity of the attorney-client privilege and what steps a party may take.
So I'm confused, counsel, if I may. Was Mr. Sorkowitz ever retained by your clients?
No, so we just learned last week that Mr. Sorkowitz is...
We're not going to, we prefer not to talk about anything that isn't in the record.
He's withdrawn as counsel. So the disqualification issue is partially moot now. So
That's a good thing to let us know. Wait a second.
Yes.
So would you put in a stipulation, please, withdrawing that? Is everyone amenable to that?
Mr. Bianchi is new counsel to defendant respondent Schweitzer RSG LLC. We were talking about getting a written stipulation, and we couldn't do it fast enough given how recently this occurred. So yes, we will stipulate that we no longer need a disqualification order from this court. The only reservation I have is that the conduct that occurred is still at issue with respect to protecting the other defendant's privileges.
It has no potential retroactive effects even if he's out?
So the retroactive effect is that the privilege information is still in the...
Exactly. He obtained from, I'm not saying that it's so, but from your perspective, he obtained privileged information. I mean, the fact that he's now out doesn't make good if he obtained privileged information, which he shouldn't have had.
Exactly, 100%.
So is that the issue before us?
Yes, the issue before you is whether or not the plaintiffs and their plaintiffs are allowed to keep, retain, and use our privileged information, and whether the...
So the appeal is not moot.
Right. Only
In
part
terms of what's in front of us today, nothing really
So
changes.
let me continue.
Yes.
There was no retainer with Mr. Sorkowitz, and there was no joint defense agreement. So how is it that you claim privilege when we're talking about a corporation, which is a person in its own right, and two individual defendants who are separate persons in their own right? in the light of a policy that said very clearly, no expectation of privacy. Schweitzer owns the rights to all data, files, and communications in the company system.
So the facts, Your Honor, just relayed are not correct. When this action first started in January of 2025, all of the defendants, including Schweitzer, jointly retained my law firm to represent them in this exact case. Then on February 25, so after about 2 months of very aggressive litigation related to an attachment that this court ultimately vacated with a unanimous ruling, the plaintiffs exercised a contractual right to appoint a receiver over one of the defendants, Schweitzer. The second that happened...
I think we're trying to do an end run here.
No, Your Honor.
No?
No, once the plaintiffs appointed a receiver to take over Schweitzer, defendant, we recognized we could no longer be counsel and act...
I'm talking about expectation of privacy.
Yes, so because we were all co-defendants together, we had all agreed to share privilege information to mount a common...
You didn't make that argument until your reply brief. So you can't rely on it now. So if you're arguing common interest, you didn't make it in your initial brief. So let's try something else. I'm sure you raised it on reply. Maybe you'll go back to the trial judge with it, but let's try something else. Because as we all know, you can't start on reply with a new argument.
No, 100%, Your Honor, you can't.
So your argument is that there is a conflict. What is the conflict?
Well, the conflict is that the plaintiffs essentially want to gain access to privileged communications that were shared with an expectation of confidence that would not be shared with them. I mean, we're talking about emails, for example, from me to all of the defendants at the same time to deal exactly with the lawsuit that is now in front of us. We're also talking
Counsel,
about...
are you what documents or what items are you addressing specifically? Has anything ever been identified, such as notes from such and such a day, or what are we talking about?
We're talking about several categories of information that were identified. At the beginning of the loan, you had obviously communications with parties on both sides of the loan transaction. So that's an adversity. And we had, for the borrowers and the other defendants, their own counsel.
Doesn't Schweitzer own all of that information?
Schweitzer is among the joint, well, was among the joint defense group. So yes, it certainly owns. There's never been an issue here, and I think that's muddled in the plaintiff's brief. We don't take the position that Schweitzer...
Now the receiver has succeeded to that interest.
The receiver has, but the receiver can't go ahead and take our privileged information and turn it over to the plaintiff.
Why is it, what privileged information are you talking about? And didn't the court below say, sure, we'll do a protective order? If you're claiming privilege, we'll do a protective order.
No, the court below... So
I am sure that that's what the court below said.
And wasn't there a stipulation that the receiver wouldn't share information?
There was a separate, can I?
Yes, of course.
Okay, so to answer the first question, the privileged information we're talking about are communications dealing with the attachment that happened between January and February between all of the co-defendants. The other privileged communications are ones related to the loan documents that are at issue in this dispute. As to the stipulation, there was a separate stipulation entered into in the other
Texas
lawsuits
litigation.
in Texas. The parties
We know
are
the
different.
record.
Yeah, the parties are different. That was the problem. We tried to enter into stipulation with them. We tried to come up with a mechanism using metadata, date ranges, filters, custodians. We could not come to an agreement with plaintiff's former lawyer. I should point out, all new lawyers on the other side here since this has all happened.
Okay.
Thank you, Your Honor.
Thank you, Your Honors. May it please the court, Michael Duke from Ellsberg, Baker, and Nerie on behalf of the plaintiff respondents and metropolitan entities. Very briefly, I just want to follow up on the loan materials that we heard appellant's counsel mention earlier. That argument too wasn't raised. That argument too was not raised until reply, so it is also waived in terms of those materials. I want to focus though on the narrow issue that's before the court, and that's that whether the trial court below abused its discretion or acted within its discretion when it directed the parties to work together to resolve this dispute by entering into a protocol that would allow for the segregation of the purportedly privileged material and for its clawback. If there was a dispute...
And counsel, if I can just stop you for 1 sec. Privileged material as to the individual defendants, yes? Not privileged material as to Schweizer?
Correct, Your Honor. And that, I think, is a great point for why a protocol is so important here. As the appellants have conceded in their reply brief, Schweizer does control its own privilege, and so we need to be able to segregate out, and Schweizer needs to be able to segregate out its own information from the information that appellants improperly put onto company systems. The policy is abundantly clear. It's at page 443 of the record. It's in all caps and says that they're not supposed to do this. So
Or if they do it, everything that they put on the system is Schweizer's, right?
Yes, Your Honor, and the Perrine Boom case cannot be
I
clearer.
mean, yeah, this is not the first time people have used their work computers to write emails that they shouldn't be writing.
I am sure, Your Honor.
Counsel, also, to the extent that Mr. Horton, defendant Horton, was the CEO of Schweitzer, he would be eminently familiar with the employee manual of his own company, right?
I sure would hope so. I would hope so. Again, the only question is whether it was an abuse of discretion. It certainly was not an abuse of discretion. This is an efficient process that the court...
So let me just ask you a question. Are you taking the position that if the individual defendant wrote a letter to plaintiff's counsel about his own defense, that Schweitzer would be entitled to that?
We're not taking a position on that issue. We, as we've stated in our brief, we have no interest in seeing this material.
Right. So that material one could presumably put on a privilege log.
Correct.
Because it's not, the person is not talking about Schweitzer, they're talking about I my individual, right? And that can be worked out.
Correct, Your Honor. I think there might be issues with waiver regardless, but we certainly don't.
Yeah, but okay, but that hasn't even been, that hasn't, because counsel, as counsel says, at that time we had a common interest. You can litigate that down the line, right? That's not before us right now. You can litigate it down the line.
I agree 100%. If there is a dispute, either party can raise it. All that is before the court is whether we should enter into or work together to enter into a protocol to allow for the segregation of purportedly privileged information and its clawback. I can't think of an alternative process that would actually work better. This is clearly within the court's discretion.
And you're willing to enter into such an agreement, notwithstanding the language of the employment manual?
I think that the issue over the employment manual would be a discussion to have if there's a dispute over the materials. So they might have waived privilege by putting it onto the computer. I think it's actually pretty clear. But that might not even be a dispute we have to have. I think the issue before the court is whether we get to step one, which is let's enter into a protocol on how to deal with the material that they claim is privileged, which again has been pretty amorphous. It's difficult to tell what they're claiming is actually privileged. We don't know what the material is. I see my time is up. Unless there are further questions, we'll rest on our briefs. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court. Evan Bianchi of Spiro, Harrison, and Nelson on behalf of Respondent Schweizer, RSG, LLC. Many of the points that we contend have already been...
Let me make clear. Let me try and make clear. So disqualification is no longer an issue. Is that correct?
That's correct, Your Honor. If you look at...
So to the extent that you sought on your appeal to reverse the trial court's decision denying disqualification, that part of this appeal is no longer an issue. Is that correct?
Yes, sir.
Okay.
Yes, Your Honor. And the stipulation of counsel, we filed that on this court's docket. We'll follow up with a stipulation between parties.
Okay.
To address the remaining aspects of the appeal,
So the issue really now is just the documents that are on the corporate defendant's file servers.
That's exactly right,
Okay.
Your Honor. And Schweizer completely agrees that the company's computer systems, company systems and usage policy renders all data, either created on, transmitted on, received on, et cetera, all of that data is the company's. There's no expectation of privacy upon any of that data, any of those communications. But of course, the question here is whether or not there was an abuse of discretion by the Supreme Court saying, parties, go figure it out.
Well, I mean, okay, your co-counsel says, well, it's all, there's no expectation of privacy, but I think the move-in is saying at that time we had a joint defense. So I think there are issues that have to be fleshed out. The question is whether we should issue an injunction here, given the fact that that issue wasn't raised until reply, and it hasn't really been fleshed out below.
We completely agree, Your Honor. I think that the simplest course here is for the parties to try to reach an agreement. It's not the inability to reach an agreement is not a basis for this court to step in and supplant the normal course. The correct course would be to go back to the Supreme Court, say, here are competing proposals, and let's have the court work it out. We think that that makes the most sense, and that's exactly what the Supreme Court intended, and at the very least, it can't be an abuse of discretion to order that. Just one more point, Your Honors. I think it bears noting that Schweizer's receiver sought this information in order to be able to do her job, which is to run the operations, maximize the value of the company. So if this court was to step in and order the relief that the individual appellants are asking for, it would create an unworkable system that would not allow her to do her job without a complete privilege review at the threshold, which is something that would hinder not only her job, it would hurt the company as well. Just a point I wanted this court to be aware of. Unless there are any further questions, we'll rest on our briefs. Thank you.
Great.
I thought it was my turn. Your Honor, the case that we haven't talked about yet is technically...
Hold on just a second.
Sorry, Your Honor.
Okay. Okay. Let me ask you now, as I ask counsel, the disqualification part of the appeal, which was denied below, is no longer an issue. You've stipulated that. Okay. Now, with respect to the documents, right?
Your Honor, one case we haven't been talking about here is the Court of Appeals decision in Techniplex in 1996, where the court very helpfully identifies two categories of documents. One, to run the day-to-day business operations company. We're not here about that. We're not arguing about that. The other communications it calls the pre-merger communications, where Tang, who was the owner of Techniplex and knew Techniplex, were joined in an adversarial relationship. That's the phrase that the court uses. Here...
Is there an adversarial relationship here?
Yes, absolutely.
Before the loan?
Yes, because we have to...
How could that be? You're asking for a loan. You're not in litigation at all.
Because there were loan documents, right? There were loan documents that were being negotiated between borrower and lender, between guarantor and the lender, again. So you had opposite sides. If, for example, you had an email with a lawyer saying, and I don't know that this particular email exists, I may oh, you know, this particular provision in the guarantee means this. Now we're saying that the plaintiffs get access to that?
Yes, because Schweitzer owns that. That's Schweitzer's document. It's not your document. It's not your personal document. It has nothing to do with you personally. That's the company. And of course, the receiver owns that document.
Well, so we're in a situation now where you could have co-defendants.
You absolutely knew that when you agreed to a big loan, not a tiny loan, a big loan, and you agreed. If we default, which you did the month after the loan was, or that's the allegation, of course. I don't know if it's true or not.
Well, yes, and
the allegation is right, but the allegation is that the company immediately defaulted. If you agree to put in a receiver to run the company, you have to understand that the receiver owns all those documents, right? Yeah, you can, sure.
I think under that standard, how could somebody fully and freely confide in their counsel? You would chill communication, and that's what AMBAC teaches us. And I do want to make one more point about Perenboom. That's an employee-employer dispute.
So we should ignore your contractual obligations because you feel like you were going to be chilled?
No, but there's nothing in the contract that says we're waiving privilege. All it is there's a contractual receiver.
It's not your privilege. You represent an individual defendant, correct?
We represent...
Who do you represent? Let me ask you that.
We represent, initially, we represent...
No, I'm talking about today, on this appeal.
Yes, we
Who
represent...
do you represent?
Brian Nerie, David Horton, and these other companies that are referred
to. So Schweitzer's understanding about what the guarantee says. That's not yours. You have no interest in that privilege document because it's not your privilege to assert or not. It's the company's privilege to assert or not. And that is the way it goes.
No, it's everybody's. If you had multiple co-defendants and they're cooperating to mount a common defense.
Did you get any money on the loan?
My clients personally, no, the money went to Schweitzer.
All right.
But if you have, this is basically one co-defendant flips, goes to the other side, talks to the government. But you can't go ahead and then turn over all the communications you had with your other co-defendants. Otherwise, you could never work together to mount a joint defense. That's the fundamental problem here. I recognize my time's up.
Thank you,
Your Honors.
AG versus Kenny S.
Good afternoon, and may it please the court. Lorena Novotnik of Mental Hygiene Legal Service for the appellant Kenny S. Kenny S. appeals as of right the final order of Supreme Court requiring him to comply with a 2-year outpatient order of conditions pursuant to CPL 33020 that restricts where he may live, whether he can travel, and what medical care he must receive. The state utterly failed to meet the burden of good cause shown for an extension of this order, and we ask that this court reverse.
Well, is there anything in this record that suggests that OMH refused his right to go to Texas?
I'm so sorry, I didn't catch that
I'm sorry.
question.
Let's use an example. He has family in Texas. You argue that his sister is ready to house himself and his mother.
Whether they'd refuse or
And
not.
this order of condition keeps him from going to Texas for 2 years.
Florida.
Separate and apart from whether you have a basis to challenge as of right, but just on that fact basis alone, I saw nothing in the record, and please correct me if there is something in the record, where your client made a formal application to OMH. May I visit my sister? And OMH said no, and therefore now I'm aggrieved because OMH has precluded me from leaving the jurisdiction of the state, which is what you claim is a breach of his substantial or fundamental liberty, substantial right or fundamental liberty interest. Is there anything in the record about that here?
Yes, not about whether they denied a request, but about the timeliness. There was testimony in the record that he'd missed funerals, that he'd missed family reunions, that he missed his niece's housewarming across the river in New Jersey.
So, Counselor, I saw that in the briefs, but there was no specificity as to when and what, and I think that's what my colleague is addressing. When you talk about ability to travel, of course, there's a question about whether a fundamental liberty interest is implicated. The question is whether the matter presented by your client is ripe for us to hear at this point in some respect, because we don't have dates. We don't have specifics.
Well, the problem isn't so much whether or not the OMH would consent to his request, it's the time that it takes to do so. So if somebody falls ill, if somebody's in the hospital, and it takes, this isn't in the record, but it takes a while to get OMH
Does anything in the
approval.
record tell us how long it takes?
There's nothing in the record about how long it takes.
For example, an affidavit that would say, I put in a request, and by the time it got answered, my beloved relative had passed away, or the graduation was gone, or whatever.
I mean, there's nothing in the record, but I think it's certainly not 24 hours.
So right. So I guess because the framework is, you both agree, you can't ask for permission to appeal, right? That's out. And the question is, and the only way you get an appeal as of right is under the Constitution and under CPLR 57, I think it's 04, right?
It's not.
And that just can't be something that's an inconvenience or I don't like that. It has to be pretty serious liberty at interest at stake that is actually being curtailed. It can't just be sort of amorphous. It can't be maybe someday. It has to be right now. That is happening.
Right.
So
I mean-
I think that is where the tenor of the questions is going.
Right. I mean, I think that the testimony here is that he was aggrieved by the travel restriction. He was aggrieved by the travel restriction because he did miss family events, and nobody is contesting that. Nobody is contesting
yeah,
that.
but it's so generalized, you know? Like, who knows whether he missed family events because he didn't get on the plane in time, or there's nothing that's really specific about what he is missing, what liberty interest he has been deprived of.
It also requires him to ask permission before changing his residence. As Your Honors mentioned, you know, he has somebody in Florida who would
So
take him in.
did he ask for permission and was denied?
No, but he can't, he can't leave the state without the.
Did he ask for permission to leave the state?
Not at this time, no. He has not asked permission to leave the state.
So again, as my colleague pointed out, you're challenging these conditions hypothetically.
No, it is not a hypothetical in this case. I mean, the testimony is quite clear and is undisputed that this travel restriction was directly
Perhaps
connected.
had he asked for permission, they would have said to him, you can go.
But it's about timeliness. Again, if somebody falls sick and
But we
you
don't
need to
know if
go
you haven't
now-
asked.
I'm sorry, Your Honor?
We don't know if you haven't asked.
I mean, that was not.
So your
that's not the
argument
record.
is that they didn't meet their burden, so there should be no restriction?
Yeah, I mean, I would like to turn that back to that at the beginning, is the burden itself. It's not his responsibility to prove that he doesn't need an order.
Under 33020, there's no dispute that the statute allows for an order of conditions, particularly given that he's an acquittee, correct?
But they need to meet a burden of good cause. It's not simply not enough.
Bear with me for a moment. And the initial 5 years, no problem. Then it was extended, no problem. So now we have a situation where the petitioner, the Attorney General, now wants to extend it for 2 years, or wanted to extend it for 2 years. And then there was there was a hearing, got that due process hearing. His own treating physician said, I think the order of conditions is appropriate.
Actually, I want to correct Your Honor on that point, because what the direct question to Dr. Belcher was, how would this clinical condition change if he was under an order versus not under an order? And Dr. Belcher said, I can't answer that question. So there wasn't actually testimony directly connecting this order for his need for a continuance of the order and conditions. It was all about this conclusory, like, oh, we need to follow him so we can follow him. You know, maybe someday.
Or a
he'll be-
trial run?
For a trial in which he's been stable. He hasn't been hospitalized in almost 15 years. He's been out stable in the community for almost a decade. There's just simply no evidence here that an order was needed. And I want to be clear too, there's no evidence that he's ever physically injured anyone at all ever. Not just in the time that he's been out on the order of conditions, but even in the instant offense.
There's a
What's the
question-
level of dangerousness?
I think that Dr. Belcher raised a question of whether he showed some remaining symptoms pertaining to his schizophrenic affective disorder.
May I briefly respond to that? So the concern was that he has mild residual symptoms that people may be entering and exiting his apartment in supportive housing. And then the testimony was also that people do enter and exit his supportive housing. And there was no testimony that that caused any problems, that he had started any fights, just simply that they saw this residual symptom. And that simply is not enough. There's no dangerousness. Reserve.
I'll ask you on reply.
Good afternoon, Your Honors. Is this loud enough?
Yes.
Fabulous. Good afternoon, Your Honors. Anaga Sundararajan for the Attorney General, and may it please the court. This court should dismiss this appeal for lack of jurisdiction because the order at issue is not appealable as of right, and alternatively, it should affirm Supreme Court's determination because Supreme Court properly exercised its broad discretion in this case. I'd like to
So under
start.
what circumstances could an individual situated as is the appellant appeal to this court?
So the statute does not allow an appeal to this court of an order of conditions by the defendant. The defendant can, as the defendant in Allen B. before the Court of Appeals did, bring a collateral challenge under Article 78 and then appeal a determination from that collateral challenge. The defendant also...
So you mean, had he asked for permission to go to Florida and had been turned down, you could bring an Article 78 proceeding and should challenge it via that route?
That's correct, Your Honor. He could also bring a habeas challenge under federal law. This is
So his mother is dying and he wants to make the funeral, and he asks for permission and they say no, and he has to do all this. Article 78 and all of that.
With respect to this court's jurisdiction, that's correct, Your Honor. In that circumstance, my understanding from OMH is that there are procedures in place to respond to emergency circumstances.
Counsel, what do you consider a substantial right?
Your Honor, we don't dispute that this affects a substantial right, but that's not the
So
standard
you don't
here.
dispute that?
No, Your Honor, but that's not the standard here because the statute does not allow for an appeal as of right
Counsel,
under this
where
appeal
in
law.
the statute does it say defendant is precluded to appeal as of right?
It does not, Your Honor. However, this court in Marco G and the Court of Appeals have made clear that appeals under Section 33020 are by permission. And the section of the statute governing appeals by permission does not authorize a defendant to appeal an order of conditions.
Are you aware of any legislative history that explains why the Attorney General has the ability to appeal as of right, and a person who is under an order of conditions may not?
So to clarify, Your Honor, the Attorney General does not have an appeal as of
Am I
right. The
saying
Attorney
the-
General may, or the Office of Mental Health may
yes.
seek an
Yes.
appeal by permission from this
And be
court.
represented by the Attorney General.
That's correct.
Yeah, thanks.
The Office of Mental Health may seek permission from this court to appeal. It cannot, the Office of Mental Health cannot appeal as of right these kinds of
So
orders.
sort of the default position about order of conditions is that they're not appealable.
The default position is that under the statute, no order under that is issued pursuant to 33020 is
330 gets
appealable
appealed.
as of right. There are provisions in place if the defendant is, if an order affects the defendant's physical custody by OMH under subsection 16 for plenary review. Alternatively, there are provisions in subsection 21 that govern appeals by permission. These are the two alternatives. That's what this court recognized in Marco G, and that's what the Court of Appeals has recognized.
Counsel, does permission to travel need to be denied for the right to be considered infringed upon?
In this case, it does for the purpose of this court's jurisdiction, Your Honor, because
So let me
here
stop you for a moment. You believe you met your burden?
We believe that this court doesn't reach that because it is a jurisdictional bar.
I want to
However,
know what danger was put forth on the record to continue these consent conditions on him. According to my memory, and correct me if I'm wrong, he missed some appointments, but he rescheduled them.
To clarify, Your Honor, he no-showed for the appointments and rescheduled afterwards.
But rescheduled afterwards.
After the fact. This is part of a
So
pattern.
failing to make an appointment and rescheduling allows us to infringe on his substantial rights.
It is, again, to clarify, this court does not reach that because it doesn't have jurisdiction to consider the merits. If it does, the burden is relatively low. The burden is good cause here, and there is good cause based on Dr. Belcher's testimony and based on Supreme Court's experience and review of this defendant. Here, what you have is
This
not-
doctor was only treating him for a year, correct?
This doctor has only been treating him for a year. Manhattan Psychiatric Center has been treating him since 2013. Their petition, which was from the physician who was treating him previously, also indicated that in their medical expertise, this order of conditions needs to be continued.
The
And I
doctor says it would be good to keep him on here as a trial run, correct?
It would be good to clarify, Your Honor, what the doctor was testifying to was in the absence of an order of conditions, he is fully responsible for managing his own medical care in all aspects. And so the trial run is not just making appointments, but is...
But he has had long-standing successful compliance with all the conditions that he's been imposed on, correct?
No, Your Honor. He has had longstanding compliance with his medication. However, he has had a pattern of missing appointments. He has had a pattern of no showing and then meeting.
But counsel, didn't Dr. Belcher say defendant has remained sober and compliant, developed insight into his condition and need for treatment, and largely complied with treatment plan, has traveled outside the state at least once for a family event and spends time with his immediate family?
Yes, Your Honor. However, he still continues to get significant support from OMH.
Let me ask you a question. So we have one psychiatrist, an expert testifying. Did Kenny put on any psychiatric testimony that would
No, Your Honor, he
Dispute
testified
that?
on his own,
But
his own
he's
behalf,
obviously, he's a party. I'm asking you, so we have one expert who says he needs another 2 years. And then we have no expert opinion to dispute that?
That's correct, Your Honor. There was no expert on the other
And only the
side.
defendant, the person himself, who is saying, I don't need any more supervision.
That's correct, Your Honor.
In the absence of a statutory right to appeal under 33020, is there an exception? In other words, your friend raises an exception for the first time in where they're saying the substantial right or liberty interest is implicated, then the Constitution would kick in to allow such an appeal. Is that an exception?
No, Your Honor. With respect to with respect to Article 4, Section 4 of this court's jurisdiction, the Court of Appeals held in Farrell or Farrell that fixes this court's jurisdiction as of 1962. However, the courts have all uniformly agreed that 33020 was a sea change. It created new procedures that did not exist. That includes new...
But how about Marco G? I mean, come on.
Marco G involves a different kind of order, Your Honor.
Oh, but it's still the same issue as whether or not any statute could take someone's right under the Constitution to an appeal, a substantial liberty and interest. Right? Yes, please.
So Marco G is not controlling here for a couple of reasons. The first is Marco G addressed the right to appeal under the CPLR, not under the Constitution. And second, the kind of order at issue in Marco G, the denial of rehearing, was one that's not addressed at all in subsection 21. And this court explained that by saying the defendant has a right to a rehearing where one is timely requested. So the legislature never contemplated that there could be a denial of rehearing under that section that could then be appealed. Here, in contrast, the legislature specifically provided for an order of conditions that specifically addressed this kind of order in subsection 21. Thank you, Your Honors.
Thank you.
I just want to first say that everyone agrees that this impacts a substantial right. Counsel has just stated that.
But if the only way you get up is, given the statute, it has to be more than that.
But I want to turn...
yes, good, yes. Everyone agrees that travel is a right that people have. But that's not what is the way you get up on as of right appeal. Your only way up is a significant liberty interest that is immediately, affected. And so that's why we keep asking you, what has happened? Has he been denied a right to go anywhere? Has he said, I don't want to take medication anymore? Is there anything in the record that would implicate that kind of interest? Because otherwise, the statute is pretty clear.
Well, the denial, he doesn't have to wait for a denial. If he's waiting for them to get back to him and then he misses a funeral or he misses a death, I mean, it's not about the denial. It is about the constant seeking of permission and the threat that you might not get it. And on top of that, I want to discuss the idea that these orders are utterly unappealable, and I want to take the court down the road of what that actually looks like. So CPL 33020 provides for any condition that the court thinks is necessary. And these orders last for up to 5 years, and they are infinitely repeatable. So what we have here is the potentiality that the Supreme Court Justice says, well, I think it's necessary for you to attend church every Sunday. And then that's it. There's no revealability at all. That is the state's position. And that makes no sense. It makes no sense. And it makes no sense here.
No, I'm not sure that that's what the state's position is. I think I sort of understood counsel as saying is that there is review here possible via an Article 78 proceeding also.
Let me touch on the Article 78 proceeding, because what they're talking about is Allen B. When Allen B. said that an Article 78 writ of prohibition was not available. So no, there isn't an Article 78 route here. And this is a constitutional right. Are you really saying that we're going to relegate disputes over constitutional
Well,
rights?
if you want something to happen and it's not happening, you can challenge it via an Article 78 proceeding.
It doesn't matter if your family member's already dead. I mean, if that's what we're saying here, is that we have a denial of a right to go and see someone across state lines, and you have to wait until after the fact, until after that moment is passed?
Yeah, but I mean, yes, the same way you're denied a license and you can't work, and there are lots of interests that are denied initially until someone brings an Article 78 proceeding. This isn't different than a lot of interests that are denied or curtailed pending Article 78 review.
But may I just briefly respond to that?
Sure.
The testimony in the record is that he had missed funerals, that he had missed family events. Thank you.
Thank you. People versus Ricky Moore.
Good afternoon. May it please the court, Justin Bonus on behalf of Ricky Moore. I think the first issue I really want to focus on, I believe that people have actually conceded to point 1 of Mr. Moore's brief. I note that they do say that I did not raise that Mr. Moore requested to go pro se before trial, but I specifically talk about the trial court and prior to jury selection, Mr. Moore requested to go pro se, specifically. So I note that there were 2 times prior to trial that Mr. Moore unequivocally requested, actually there were 3 times prior to trial that Mr. Moore unequivocally requested to go pro se. The first time is prior to the hearing on August 2nd of 2018. He requested to go pro se. There's no colloquy here. There's just, no, you can't do this, and we're going to proceed. He never asked for an adjournment, by the way. And I think the people neglect to really get into and mention the fact that while this case had been going on for quite a while, there was a hearing done in this case, there were multiple motions in this case. This case is a lot like Lewis.
Counsel, there were 4 counts. There was substitution of counsel 4 times, is that? Substitution of counsel, how many times did it occur?
He attempted to substitute counsel. Are you saying that?
Wasn't it 4 times?
Yeah, I believe it was.
His attempt to substitute his 4th attorney was denied?
Yeah, he did have 4.
And the application to go pro se came after that?
Yes. The application to go pro se came after that, so.
After that 4th application was, sorry, application to change his 4th
Yes.
counsel was denied?
Yes, so he did, I think he had 2, potentially, he had 3 attorneys, and then he went pro se during the suppression hearing in front of Judge Olbis.
Did the judge consider this to be a dilatory tactic?
Well, it would be, I don't think you can.
I'm asking.
No, I don't think it's dilatory at all, Your Honor.
Did the judge indicate at any point that this was a dilatory tactic?
No, I don't believe she did. I believe it was more of he was being, it was his conduct. It was not dilatory because Mr. Moore specifically said before the hearing on August 2nd that he'd do the hearing pro se. And Judge Bybin specifically says, no, you can't do the hearing because we're in the middle of the hearing. Well, the hearing hadn't started, okay? The hearing hadn't started.
Wasn't there an issue as to what the scope of Mr. Greenberg's representation was going to be, whether Mr. Greenberg, attempted counsel number 5, was going to handle the trial in addition to the suppression hearing?
You were a little.
I know.
I apologize.
No, it's not you. I know it's me.
Okay.
With respect to the scope of the proposed substituted counsel, Mr. Greenberg, wasn't there a question as to the scope of Mr. Greenberg's representation? In other words, your client did not indicate that Mr. Greenberg would handle the trial in addition to doing the suppression hearing?
Well, correct. There was an issue with regard to Mr. Heinzman. Mr. Moore retained him for just 30-30 purposes, and the court assigned him 18B for all purposes. And so what happens is there's a dispute between Mr. Moore, and this leads to Mr. Moore filing a grievance, which was a part of my 440 motion that was consolidated on this case. I believe was granted in this case, and it was consolidated. But Mr. Moore actually files a grievance. Mr. Moore wrote letters to the court saying he was having problems communicating with Mr. Heinzman. Mr. Moore was upstate in Clinton between when the motion was filed in.
But Mr. Heinzman was the fourth attorney. I'm asking about Mr. Greenberg.
Yes.
Purported,
And then Mr. Greenberg.
purported attorney number, fifth attorney. That, I didn't mean to stop. I meant five.
He would have been the fifth. That is correct. That's correct, Your Honor. He would have been the fifth. And again, Mr. Moore twice before the hearing and then at the end of the hearing, if you go to page 70 and 72, he says, I don't want Mr. Heinzman as my lawyer. Then in August 28th is when Mr. Greenberg comes in. And what's interesting is the trial judge says, we're going to have a trial on October 4th. Mr. Greenberg says, I can't appear in October. I can appear later in October. And the trial judge says, no, we're going to have a trial on that date. And it causes basically discord between Mr. Moore
Does
and
the
Mr.
defendant
Greenberg.
never say that he's retaining Mr. Greenberg for all purposes?
Yes. Mr. Greenberg said that
Oh.
he believed it was for all
And
purposes.
does he subsequently retain him for all purposes?
No. That's, well, I mean, when a judge puts a defendant's back against the wall and it essentially causes the attorneys, I think the bottom line is what I believe that Lewis says, the 2025 case is, there has to be a colloquy. There's never a colloquy here. And the colloquy is, do you understand that you are jumping off of a building without a parachute, right? You're going without a lawyer. And Mr. Moore understood that. He had done it before. He did it in the suppression hearing. He understood that, but he was never asked that question. It was, no, you can't do it. And for 56 pages before trial, it was, no, you can't do it. The bottom line.
Didn't the court say that it was open to substitution if Mr. Greenberg could work something out with the defendant, because Mr. Greenberg initially said that he would not be able to resolve the question as to the scope of his representation?
Right. There was some type of off-the-record conversation between Mr. Greenberg and Mr. Moore.
But didn't the
Judge
court?
Bybin said, I don't want to allow this substitution unless he's going to be counseled for trial. This is your fifth attorney,
Right.
and this case is 4 years old.
Right.
And Mr. Greenberg said, I think I'm going to be counseled for trial, and your client said, no, he's not.
Well, he says that he's going to be, that he hired him for the purposes of handling the 30-30. He does not equivocally say that he's not going to be trial counsel. There's confusion. Mr. Greenberg
No,
says,
Mr. Greenberg never says that. Mr.
Right.
Greenberg says, I have been retained for all purposes.
Right.
Greenberg then says, I am under the impression that I'm retained for all purposes. And the defendant interjects on the record and says, no, he is not.
Well, at the end of that date, Mr. Greenberg says, I have to talk to plaintiff.
Yes, and Judge Bybin says, try to work it out.
Right.
So she's not saying no to the substitution.
Well, but that's not my problem. When I say that's not my issue, that's the 440.
Your issue is that he requested to go pro se.
Exactly.
Twice, in passing.
Three times, actually.
And then they meet again on January 22nd
Yes.
for jury selection.
Yes.
But the 5 months before that, he never asked to represent himself. He never retained Greenberg, and he didn't make any applications to relieve Heinzman until jury selection.
Well, jury selection, he said he was ready to go, and he wanted to represent himself pro se. And Lewis had four. Maybe he might have had 5 or 6 attorneys in the Lewis case with the Court of Appeals. Okay, if you want to go pro se, that's your Sixth Amendment right. He did it before. And what I'm saying is if there's no colloquy as to the danger of going pro se, then the court, that is a structural error. You have an indelible right to go pro se. That's the Sixth Amendment.
Except in the situation where you say you want to go pro se because you're annoyed at the judge or you're annoyed at your lawyer, and then a couple of minutes later you say, never mind, right? And a couple of minutes later you say, never mind, let's go to the hearing. So you only get the colloquy when you make a clear, unequivocal, consistent request to go pro se. Not when you are saying, I'm just annoyed at everything that's going on here, and I want to just represent myself, right? There's plenty of cases like that, correct?
There are.
Right, okay. Anyway, your time is up and you have time on rebuttal. Thank you. Counsel?
Good afternoon, Your Honors. May it please the Court, Samuel Goldfein on behalf of the people. I just would like to start off by saying that I don't believe I conceded anything. Mr. Bonus said I conceded 2 points. I'm not sure what the second one was, but I certainly didn't. I didn't see any argument about the pro se request before trial, but the trial judge tried to go through the pro se colloquy with defendant, and he steadfastly insisted that he would not
Before
follow
trial, he
court
wanted a substitute counsel, right?
He also wanted the substitute counsel at trial. I don't believe that is
Did
raised
he
on.
ask to go pro se before trial as jury selection was starting?
He requested both new counsel and to go pro se before trial was started. I don't believe any of those were raised on the appeal, but if they were, those decisions were completely appropriate. The record speaks volumes. On the pro se request at the 3030 hearing, it was equivocal, it was tentative that he would go pro se, and it was overshadowed by other complaints about the scope of the hearing and about counsel's performance. This case bears no resemblance to Lewis, where the defendant stated unequivocally that he wanted to represent himself, and the judge actually asked, do you want to represent yourself? And the defendant said yes. Here, the judge said, do you want to make a record of your objection? And the defendant said, no, I don't have any objections. I would like to go forward with the case.
And there were court appearances where he didn't request to go pro se.
Absolutely, Your Honor. Then there was a break in the proceedings so that defendant could speak with Heinzman, his fourth retained counsel, who was retained specifically for the 3030 litigation. And afterward, Mr. Heinzman said that they were in lockstep agreement on how to proceed with the hearing. Defendant raised no objection, which was particularly telling here.
Wasn't Mr. Heinzman successful in getting one of the indictments dismissed?
Mr. Heinzman's litigation in this case was remarkably successful. He had an entire indictment dismissed. He got within a stone's throw of having this indictment dismissed. It was but for defendant's willful refusal to get on the bus and go to court. This indictment would have been dismissed as well. So I think there could be nothing to say about Mr. Heinzman. The judge said that he did not only what was required, but he provided excellent representation. I think that's completely accurate. On the new attorney request, defendant's complaints were not serious. They were obviously delay tactics. The judge asked defendant to explain his reasons, and he refused. Defendant said he wasn't communicating with counsel. The judge said, what did you want to talk about? He said, it's too late now. He wouldn't elaborate. Defendant complained that he hadn't seen the motion before turning around and admitting he'd not only seen it, but signed it in open court. And then he claimed that the motion was meritless, which is surprising. One, if he didn't see it, how would he know? And number two, because the motion, as Your Honor pointed out, was granted. Justice Bybin was confused. She'd never seen a defendant object when his motion was granted. With respect to Mr. Greenberg, who would have been the fifth attorney, just 2 brief points. First, defendant requested to have Heinzman appointed as 18B counsel. It wasn't a sua sponte decision on the part of the court. Second of all, the problem with Mr. Greenberg was not scheduling. There was a scheduling problem, but the court was willing to move past that. The problem was what he was retained for. He said on the record he was under the impression he was retained for all purposes, and defendant interrupted to state, no, he is not. Then when they had time to resolve that, the judge allowed them time to resolve it. Mr. Greenberg said, we cannot resolve this today, but work something out and I'll entertain it later. Defendant never came back with another attorney. So I think in that context, it's clear that it was a delay tactic. I know there are a lot of other points, but unless there are any other questions, I'll rest on my brief and ask that you affirm.
Thank you.
I would just point to page 70 of the August.
One second. Okay.
I got you. I would just, and you're right, Your Honor, there are other cases like that, but there's not a case where a person says over and over and over again that they're ready to go pro se, and they did a Wade hearing, they did a suppression hearing, and there's nothing dilatory about this. This case went on because, well, this case went on even with those other attorneys. Motions were handled, the whole hearing was handled. He conducted the whole hearing, and there was only one time when Judge Obis reprimanded him, which was at the beginning of the hearing. Okay, so he's done this before, but I just wanted to point to August 2nd, beginning page 70. Does the defense rest Mr. Heinzman? No, yes. Defendant, I would like to make an objection that I'm objecting to him being my attorney, and you have him for the hearing. I'm just objecting to that. Mr. Moore, yes. And the judge goes on to say this is a complicated matter. Page,
But, okay, no, and I want to represent myself right now, correct?
that's
Nothing, okay.
That's what he says. And you know,
No,
I
he
have.
doesn't say I want to represent myself right
says-
now. He says I want to object.
He says, she says, I'll hear your pro se application after we handle this. That's a problem. That's a huge problem. But I just want to point something out, what Mr.
No, your
Heinzman
time
says.
is up.
He says,
Your time is up, counsel. We've read everything, we got it, we'll look at it, okay?
I just wanted to say just one thing.
You're going to say it whether, no matter how many times I said, and everybody behind you is waiting for their turns, okay? Thank you. Okay.
13.
Yeah.
13.
People v. Tony Manley.
Good afternoon, Your Honors. My name is Stephen Burko, and I represent...
Counsel, just wait a minute.
One second.
She has to set the clock.
Give us
We
a
want to
second,
give you all
one
your
moment.
we want to give you all, every second of the time to
Thank you.
which you are entitled. Okay, go ahead.
Good afternoon, Your Honors. My name is Stephen Burko, and I represent Appellant Tony Manley on behalf of the Legal Aid Society. Your Honors, two outcome-determinative facts are not in dispute in this case.
So where on this record, since it's undisputed, that in any way, shape, or form, the judge delegated his required duties of jury supervision to the court officer?
Well,
I
what's
couldn't
not-
find it anywhere.
Yeah, what I'd like to point out to the court, the people don't assert that before the judge excused prospective juror Fuchs, there was an on-the-record inquiry on the part of the judge to the prospective juror. And nor...
But may I interrupt you for a second? But he did put on the record that he excused the juror and the reason, correct? Later on, he put on the record, I excused this juror because he said he recognized the defendant, correct?
He put that on the record.
And then at that time, did the defendant's counsel make any objection?
Well, I'd like to, your question has two parts.
I just want to know, it's a pretty straightforward question. So there is a record that not at the moment he excused the person, which may be would have been a better time to say it, but later on the record he says, I just want to let counsel know I forgot that this is why I excused this juror. At that time, was there any objection by defendant's counsel?
Well, first, I'd like to address the first part of your question.
That last question is a yes or no.
the
That last
assump-
question was a yes or no question.
Pretty straightforward.
Well, but it doesn't
Counsel,
bear-
don't, come on. Respect our justice presiding, please.
Okay, the
Yes or no?
judge at the end of the trial placed a reason on the record, but that's not relevant. Under the statute, what's relevant is the judge was obligated to make an inquiry of the jury, of the prospective juror, as to the juror's fitness to serve.
Are you ready to answer the question posed by our colleague? It was a yes or no, counsel.
Well,
Was there an objection made?
there was no objection, but under the
Okay.
law, under this court's own law, as it articulated in People Against Pinckney, a case that's 25 years old at 272 AD 2nd 52, no objection needs to be made.
Because why?
Because-
Why? Is this?
Because issues of delegation of judicial authority are mode of proceeding errors. They're mode of proceeding errors.
So then that goes back to my colleague's question to you. What is the delegation that you're talking about?
The delegation is the judge's error was in not making an inquiry of the juror. So, as to the juror's fitness to serve, that failure to make an inquiry was in violation of CPL 270-15-1B, which obligates the judge to do so.
No, it obligates the judge to make a decision. If I see a jury questionnaire where the juror says, I don't think, I live within 6 minutes. I don't have to ask I don't have to ask the juror anymore. I can excuse that juror.
Well,
I don't have to go any further. If I get a fact that leads me to believe that this juror is not right for this jury, I excuse. There's no extra thing.
With all
going
due
on.
respect, Your Honor, that's not the law under 27015B.
Okay.
That statute obligates a judge to, quote, to ask questions affecting their qualifications to serve in the action. No such questions were posed. There's no record of that.
The questions were posed. The problem is that the answer was conveyed via the court officer rather than directly from the juror to the judge.
That is the problem. That's exactly the problem.
The question was posed.
And under Pinckney and Tolliver, the Court of Appeals case going back to 1996, the fact that the questions and answers were entrusted to the court officer, that is an improper delegation of the court's authority, and it's a per se reversible error.
No, did the court officer ask the prospective juror any questions?
It's not a question of whether he asked.
Again, you're not answering my question.
Court
And really,
officer-
hold on. First of all, please, don't speak over me. Really, I can't hear you. I want to hear your argument. It's really incredibly disrespectful for you to do that. So the second thing is I'm asking you a question because I want an answer and I want to be able to understand your argument. I'm not trying to trick you. I'm not trying to put you down. I just want to know. Did the court officer ask that prospective juror?
We don't know.
And is there anything in the record that would suggest that that court officer asked that witness any questions?
The record states this: the gentleman speaking with the court officer, is there a concern? Why don't the court officer come up and tell me what it is? I will excuse number 4, Mr. Hughes. I'll explain to the lawyers later. That's not an inquiry of the court. We don't know what happened.
Okay, thanks.
Good afternoon, Your Honor. Stacey Nadell for the people. As to the delegation of a judicial duty issue, because there was no delegation of a judicial duty here, this issue is unpreserved for the court's review.
Because you're saying because the court officer didn't decide whether to excuse the juror?
Correct. The court officer.
What about counsel's argument that the court had the obligation to question the juror himself?
So what's most important here is that the court officer merely conveyed information to the judge who made the ultimate decision to excuse the juror. The court officer was not the one who excused the juror. It was the judge who exercised full control over the proceedings. And
wasn't there, is there a red light on?
Yeah, no, I have to check. Go ahead.
We need context here. My understanding is that this juror was questioned by the court generally in the box. And there was, in the colloquy, it was pointed out that I think that he lived near the shelter, near it. Initially, and then there was that discussion. Then so there was a discussion, or there was inquiry between the court and this juror. It was set up, and somehow this particular juror, as we understand from the record, after I think I recognized the defendant. I got, based on everything we've heard, I think someone should know about it. So we called over the court officer, told the court officer, I think I recognize the defendant. I think I've seen him near where I live. That was communicated to the court, who ultimately made the decision to discharge this jury, correct?
correct, Your Honor.
Okay. Court officer had nothing to do with that process, except to be a conduit of information.
Correct.
Okay. Now, perhaps the better practice would have been, as my colleague pointed out, to put everyone on notice right then and there and go through that whole Sturm und Drang there. But he did it later on, correct?
That's correct.
And there was no objection from the other side.
Correct, Your Honor. There was no objection at all. This was required to be preserved, and it was not.
Would it be accurate to say that there were 3 opportunities for objection as to the judge's delay in providing the basis for excusing the jurors? I believe the record indicates that there was no objection when the juror was actually excused, also when the procedure was adjourned on August 3rd, or when the trial was commenced on August 4th.
Correct, Your Honor. There was also no objection when the judge charged the jury or when the judge explained to the lawyers the reason for this jury.
There's no question that this did not happen in the way it should have happened. But the question is it's going on in open court, and everyone's party to the fact that the judge says, the lawyers see that the judge had this conversation with the court officer, and the judge announces, I'm going to excuse that juror. Defense counsel would have had an opportunity at that point to say, hey, judge, what's going on?
Correct, Your Honor. And as mentioned, the defense attorney did not do that, therefore did not preserve the issue. And even on the merits, if this did not have to be preserved, this claim is completely meritless. As mentioned, the prospective juror had stated on the record that he was familiar with the area. He attended New York University. And then, as we know, told the court that he actually recognized the defendant. So in that case, there's really no, there were no further questions that could really cure the fact that the prospective juror recognized the defendant and dismissal was appropriate. And
So he put everyone on notice when he completed the questionnaire. I know this area, I go to NYU, and I am familiar with the area.
Correct.
And then later on, as he's looking at the defendant, he calls the officer over and says, oh my God, I recognize him, I know him from the neighborhood.
Correct.
The judge sees that, calls the officer up and says, what's going on? The officer's like, Judge, he actually recognizes him from the neighborhood. The judge says, I'm excusing him, I will explain to everyone.
Correct, Your Honor.
It's not the officer questioning the prospective juror, correct? It's the prospective juror telling the officer.
Correct, Your Honor. Yes. And if there are no further questions, we ask that you affirm in all respects. Thank you.
Hold on one second.
So
Hold on one second. I guess I'm not speaking into the microphone. Hold on one. I want to give you your time, so
I appreciate
give
that.
me a minute. Okay.
Counsel, I want to briefly discuss Williams and Ocampo. In Williams, the Court of Appeals found that delivery of the judge's answer to a jury by a court officer was ministerial, and in Ocampo, we found that a clerk's questioning of prospective jurors regarding impartiality at a judge's directive was ministerial because in both situations, the decision-making remained with the judge. How is this case different?
This case is different than Ocampo because in Ocampo, it was a preliminary question that was posed to the general panel, and some jurors came back after a break in voir dire and came back and they had rethought their initial answers. And at that point, a court officer or a law secretary went into the juror's room and asked further questions. But when they came back, and this is the key distinction, the judge posed questions going to their fitness to serve to those jurors. I would like just to take the last few seconds of my time to read this court's opinion, and people again.
You actually don't have any more time, and but we appreciate it. We've got your briefs. We've got the record. Thank you, counsel. Trinity Center LLC versus Subs. One, give me a minute. Okay, good. You may begin.
Good afternoon, Your Honors. May it please the court. Mitchell Oakes with Becker, New York. May I say it's always an honor and a pleasure to appear before this court. I represent Trinity, the appellant in this case. Trinity's a owner of a large 1 million square foot building just north of Trinity Church. I'm in an unusual position because I'm the appellant. There's been a finding that respondent has breached the lease agreement and has done so in numerous ways, including failure to pay rent, unlawfully holding over, and then abandoning the premises with 4.5 years left on the lease.
So the central issue here, counsel, you would agree, is whether the $40,000 cap that's in the agreement, a little unusual, bars you from getting the full value of the rental obligations that you think you're entitled to here.
Correct, and I come at it two different ways. One is a well-settled general principle of contract law that where a party breaches an agreement, he can't then invoke a limitation of liability for damages that that very breach caused. Now here, there were multiple breaches, as I said, not just one. So that's one way of going at it. The corollary, by the way, to that rudimentary contract principle is that as the non-breaching party, my client should be made whole, get the benefit of the bargain.
But, okay, you can be made whole, right, if you go after the person who is actually in the premises.
Can't do that.
Why?
Because there's a provision in the lease that says I can only go after Subway corporate.
Okay.
And it's in our papers.
And so the sublease, where does it say that you can't go after the sublessee?
Hold on one second, if you'll give me a second. Yep, did I do that? It's a footnote, Your Honor. It's all in all caps. Bear with me just 1 second.
In which document, the lease, the insert, the writer, or writer
Page
two?
24 of our opening brief.
Okay.
Should I read it? Or?
Yeah, just let me.
Landlord recognizes and acknowledges that the sole and exclusive person or entity against which it may seek damages or any remedies under this or any other document in which the landlord and tenant or landlord and sublessee, that's the franchisee, are parties, whether for unpaid rent and associated damages, claims of unjust enrichment, claims of unfair trade practices, or any other theory of recovery of any kind or nature, is tenant or sublessor. That's Subway corporate.
This lease was offered by your client?
No, none of us, unfortunately, this is the way it always happens, isn't it, Your Honor? None of us in this room were there when they negotiated the lease. This is from what I can gather, a standard form Subway lease that was severely negotiated and limited. And I know that because there are other cases in which other Subway leases are at issue. And in those cases, and I think it's 330 Livingston is a case that's not in the briefs. It was in the briefs below. There was a provision in there that said this limitation, this $40,000 limitation, this limitation of liability is a total aggregate liability limitation.
For recurring rent obligations, right? For recurring rent obligations. We're not talking about other breaches. We're talking about rent. So the landlord says,
I'm sorry.
1 second, the landlord says, I agree, notwithstanding anything else of the lease, which of course is a specific that modifies the general. My sole remedy against SRL for such recurring rent obligations, we're not talking about damage to the property, we're not talking about anything else, but recurring rent obligations shall not exceed the lesser of $40,000 plus the security or the remainder of the rent due. I mean, that's pretty straightforward. That's pretty straightforward.
No, I disagree, Your Honor.
All right, I read a lot of contracts. I drafted a lot of contracts. I know a lot of contracts. To me, that seems pretty straightforward. Why is that not?
Well, first of all, because we say, Your Honor, that this provision is triggered post-termination of lease.
Where does it say that?
It says landlord and tenant agree that in the event of a default by tenant and termination of this lease. Okay, so it's triggered when the lease is terminated. It has nothing to do with damages for past rent.
No, that's the first sentence. The next sentence says, upon any default in the payment of base rent and or regular recurring rent, Trinity's claim is, that sentence doesn't talk about and the lease is terminated.
Well, it's in the...
That sentence talks about if they don't pay, my liability, my rent liability is capped at $40,000 plus a security deposit.
It talks about, with all due respect, Your Honor, it talks about recurring rent obligations for the remainder of the term, which is.
I think we can understand a distinction between rent obligations through the term that they defaulted in on paying, which you were seeking, as well as you're seeking post-use and occupancy, correct? Post-vacature use and occupancy would be an exception to this cap, correct?
Use and occupancy?
Would be an exception.
Well, because it says here, in the same paragraph, Your Honor, nothing shall limit landlords, this provision shall not limit landlord's right to bring a claim against tenant for other amounts.
Which would be use and occupancy.
Do not constitute recurring rent
Right,
obligations.
that's my point.
That's
not a recurring rent.
correct.
We
That would be-
recognize you have rent owed based on the defaults, which this clearly acknowledges breach of the lease. So the argument that they're not, they should not benefit from this because they breached the lease. This specifically says default, which means it anticipates breaching a lease.
But not every default, Your Honor.
I didn't say it. Okay.
Not every default. We would say an abandonment.
It says upon any default.
Pardon me?
It says upon any default.
In the payment of recurring rent obligations. We can debate it, Your Honor. Obviously, we're doing that. Something that is past due can't recur. It's already been past due. We also say that this is a mitigation.
No. That means recurring in the general course of, that means monthly rent, obviously. Everyone knows that. So that's a distinction that you're making that I don't agree is something significant. But counsel, my colleague has a question.
Yes, with respect to termination, the termination of the lease was June 8th, 2021?
Correct, Your Honor.
And then the franchisees continued in occupancy, running their businesses as Subways until September. So we have rent due until June 8th, and then use and occupancy after June 8th until September
Yes.
something?
And then 4.5 years of addition of rent due under the remainder of the lease term, which
you capped at 40,000. You, not you, thankfully, someone.
Yeah, look, to be certain, there's a cap. The argument is there were multiple defaults, there are multiple buckets. There's past due rent, there's use and occupancy, there's future rent through the lease term, there's attorney's fees, and there's mandatory interest. We think we have concession on the last three. We think we have concession on use and occupancy. We think we have a concession on attorney's fees. At the hearing, not my worthy adversary here, but his prior counsel conceded on the record that attorney's fees are not recurring rent obligations.
Yeah, but you have to be a prevailing party to get the fees, right?
And we were, Your Honor.
Well,
we were.
Okay, thank you, counsel.
Thank you.
Oh, I'm sorry. That's all right.
Go ahead, counsel.
Good afternoon, Your Honors. Dave Roth of Wigan and Dana for Respondent Subway Real Estate. I want to start with the limit of liability. This is in Record 104. It says that upon any default in the payment of base rent or any other regularly occurring installment of additional rent, which it defines then as recurring rent obligations, the landlord's claim for those recurring rent obligations shall not exceed $40,000. Now, counsel made an argument in his briefs and here that we can't enforce that provision because we breached the lease. I think every case that has ever raised a limit of liability, the limit has been raised by the party that breached. That's the party that has the liability to limit. So I think that just can't be considered.
Let's address attorney's fees. Do you agree with counsel that there was a concession that you should be the prevailing attorney's fees should be awarded?
I agree that attorney's fees are not recurring rent obligations.
Oh, okay.
So they're not subject to the
Right.
cap. Now, they still have to.
Well, right, you have to be a prevailing party.
Not to put a fine point on it, he's sitting here, he's arguing that everything the trial court did was wrong.
So how, right.
I don't think he's the prevailing party because he lost on what the fundamental issue was, which is can they recover more than $40,000? So they're not a prevailing party. So the only question then, oh, go ahead.
I mean, maybe we're going to say the same thing. your position is that in addition to the $40,000, there is nothing owed between the time of the termination of the lease and the time that they leave?
Yes, that's right. So for the use and occupancy here, they're seeking a contractual use and occupancy,
Yes.
which is defined as just the base rent plus the additional rent times 2. So they're seeking rent. It is rent under the terms of this contract, and that's what they're seeking. Now, theoretically,
why is that not? Why do you think it's capped by the 40,000?
because it's a recurring rent obligation, it's base rent and additional rent times
Is the
2.
fact that it's post-termination, does that make it any different?
No, it doesn't. And it also, the recurring rent obligations are anything that's base rent.
Was the lease terminated?
It was terminated.
So then it's not it's not rent, it's not recurring rent, it has nothing to do with recurring rent.
If they had
It's post-termination use and occupancy, which is, as we all know, a different animal.
I would agree with that if they had sought use and occupancy as a sort of quantum merit, but they didn't. Their claim is you breached the contract because you didn't pay us this form of additional rent and base rent that you owe us. So it's
We
just
terminated the contract, and then your client held over, and guess what? As an accommodation to everybody, and so we didn't have to fight it post-termination, we all figured out what the number was going to be of your post-termination U&O. Not rent, post-termination U&O. That's what we all agreed would be the number, because we don't want to have to bring in 2 real estate brokers and 3 experts to decide what the fair market value of the property is in 6 or 12 or 18 years. We're going to decide right now so we save ourselves that money. That's what that means, doesn't it?
No, I don't think it does, Your Honor.
Oh, I was just going to echo my colleague's point that there's a difference between rent and as it's defined in terms of a monthly rent with a certain sum versus a separate section that talks about per diem use and occupancy charges that describes how to come up with that formula as opposed to getting an expert witness to come into court to determine what the market value would be for use and occupancy. And there is case law that supports that type of use and occupancy being awarded, and it doesn't mean it's a recurring rent obligation.
Usually I would agree with that, but I think what I'm saying here is it meets the definition of a recurring rent obligation.
Why?
Because
Why?
it's calculated as the base rent and the additional rent. It's just the base
No,
rent.
no, that doesn't make it rent. The fact that everyone agrees when you enter into the lease, what post-lease U&O would be, that doesn't make it rent. It just makes it available as a number so that you don't have to have a post-lease hearing on what the UNO would be. It doesn't change what it is, it just changes how you calculate it. The same way your damages are, as you're arguing, capped at $40,000. Instead of having to go through every month's rent and what the additional, you agreed on that in the contract, and you agreed that if the lease terminated, you get post-lease UNO, which is not a recurring. I mean, there are lots of cases that say, I think my colleague said, that post-lease termination UNO is not rent.
Your adversary argues that there's a third period, which is the period post-termination until the end of the lease, which would be more or less 4.5 years, I believe is what he said. What's your position there?
So they conceded below that was subject to this cap because
The 40,000
that's
cap.
a recurring rent obligation. It's the base rent and the additional rent for the balance of the lease.
So in
that
your
is
view,
also within this cap.
So in your view, what we're discussing is the period between the termination, I go back to where I started, the termination and September.
So there's 3 periods. There's
yeah.
the pre-termination, post-breach, the past due rent. That's recurring rent obligations because it's rent. There's the use and occupancy, which I contend is rent because it's defined as base rent plus additional rent times 2. And then there's post-vacating rent, which is also base rent and additional rent. So that's also subject to this cap.
Thank you.
Thank you, Your Honors.
Counsel, you have 2 minutes.
I'll be briefer than that, hopefully. It's been a long day for you guys, for sure. Two things I want to say, and I know they're in the briefs, but because of what we're talking about, I want to make this point. You don't just look at the words on the page of the contract. You got to look at the context. You got to look at what makes common sense here and what makes commercial sense here. And I will concede to you that I would not be standing before this court had they been paid up through their quit date, through the time they abandoned the premises. Had they been paid up through that point, they still would have owed $700,000. That's the 4.5-year number. I would have been made whole. The contract would have made sense because I would have only gotten $40,000 for that $700,000. I would have had possession of the property, so I would be incentivized to go out and re-let the space and mitigate my damages, which is a word used in that provision.
No, I think we all understand your post-termination UNO argument, but I don't know how you get around your pre. I think there are a lot of reasons why people agree to cap their number. It's one, to force the landlord to call the default and not just let the tenant stay. This is a tenant, an over lessee who doesn't have control of the subtenant. And so that kind of cap forces the landlord to call the default and not just let the number go up and up and up. That's a very common thing. But I think we all understand your post-argument UNO argument.
And then the last point I'll make, and it's addressed to you, Your Honor, the opinion does call us a prevailing party. It says both parties prevailed, but there is no reciprocal attorney's fees provision in a commercial lease. That's only in residential leases. We won. They may have won some things.
Which means everybody goes home generally, no?
Pardon me?
Which means everybody goes home.
I'm not sure.
In other words, each side eats their own fees if it's like 50.
No. We were a prevailing party, and we have a prevailing party provision in the contract.
Okay.
They don't get reciprocal, and we did win on liability. We won on liability, we won on damages. They said that they were forgiven because of COVID to pay anything, and we prevailed on liability as well as some damages.
Okay, thank you.
Okay.
People versus Shahanda Hart.
Good afternoon, Your Honors. Alyssa Benazzi with the law firm of Deckard LLP, and we, along with the Office of the Appellate Defender, represent the appellant, Ms. Shahanda Hart. Ms. Hart's conviction should be
Are
overturned.
you representing as pro bono counsel?
I am.
Thank you so much. We so very much appreciate your time and the energy and effort that you've put into the case.
Thank you, and we appreciate the opportunity to be heard.
It's exciting to be able, have you argued in the first department before?
I have not.
Oh, so good for you. Okay.
Thank you. Ms. Hart's conviction should be overturned because it was based on blurry surveillance video footage and vague descriptions of appearance, and also because the prosecution improperly unsealed arrest photos to bolster its weak case. No eyewitness testimony ever placed Ms. Hart at the scene of either of the two incidents in this case, and none of the alleged actions can establish the mens rea necessary for acting in concert liability. And this court can only sustain Ms. Hart's conviction if the evidence excludes beyond a reasonable doubt every reasonable hypothesis of innocence, and the inference of guilt is the only one that can be fairly and reasonably drawn. Given the record, Ms. Hart's conviction should be overturned as against the weight of the evidence and as a remedy for the prosecution's use of the improperly unsealed photos. Turning first to the weight of the evidence issue, in the Tomashov incident, the only evidence that placed Ms. Hart at the scene of the crime was blurry surveillance footage. And the jury could not look at that blurry surveillance footage and be justified in finding beyond a reasonable doubt that Ms. Hart was the person portrayed in that footage. Again, Ms. Tomashev never identified Ms. Hart, no eyewitness ever placed Ms. Hart at the scene of the crime, and that video footage is the only thing that placed her there. And even if we assumed Ms. Hart was present, the action seen of that person in the video, they arrived in a car, they briefly got out of the car, walked down the street, came back to the car, got in, and then drove away. Those actions are not sufficient to establish acting in concert liability for the robbery of Ms. Tomashev. while there may be one inference of guilt from those actions, there are other reasonable inferences of innocence that could be just as reasonably drawn. And as to the Brandenburg incident, again, no eyewitness identified Ms. Hart. Ms. Brandenburg, who was in the car with the person who is purported to be Ms. Hart, never identified her. She said she could not identify any of the people in the car with her, despite them sitting next to her. All she did was provide very vague descriptions of a person in the car with her. This person was young, pretty thin, short, straight, dark hair, maybe a bob thing. Those are incredibly generic descriptions. None of them are unique to Ms. Hart. They could be used to describe many people. These are not unique, immutable characteristics that can be only applied to Ms. Hart. And again, in this case, even if we assume that vague description is Ms. Hart, the actions described by Ms. Brandenburg in her testimony, which was inconsistent and fairly vague, do not attribute any of the actions that could be used as the basis for acting in concert liability to Ms. Hart. The only action attributed directly to this person with the bob haircut that we are supposed to assume is Ms. Hart was that she called Ms. Brandenburg ghetto. And making fun of someone is not the basis for criminal liability. The other actions, passing around the purse, that was never attributed specifically to Ms. Hart. Ms. Brandenburg couldn't say for certain who had done that.
Also, Tomashev wouldn't be able to identify her because she was in the car, right? She wasn't the one who, she was in the, right? Okay, so it's not it's not surprising that Tomashev didn't say, oh yeah, I'm gonna identify her, because she wasn't the one who actually went up to her, right?
And I think that goes to, that is correct, that goes to the lack of evidence of Ms. Hart's intent. The complainant wasn't even aware that Ms. Hart was there. She wasn't aware of the car across the street. So there were no actions done by Ms. Hart to Ms. Tomashev or even around Ms. Tomashev that showed she had some intent to deprive Ms.
But there were photos that identified her, and they were shown to the jury, and they look like the defendant in the case, right? Who's sitting in front of the jury.
Are you speaking of the photos at the Citgo and CVS?
Right.
So those photos come 90 minutes after the case.
I mean, I'm looking at them myself. I printed them out. They are the defendant, right?
And
the jury is entitled to draw whatever inferences it thinks is appropriate. Correct?
Correct.
And we don't lightly take a jury verdict and overturn it.
That is all completely correct.
Right.
The jury is entitled to draw those inferences.
Right.
However, if this court is given specific authority to review the weight of the evidence, and in doing so, it has to ask, was the jury justified in drawing that as the only reasonable inference? And those photos are from 90 minutes after when these two crimes were committed.
Plus, there's video evidence of her getting in and out of that car, correct?
Well, that video evidence of her getting in and out of the car is incredibly blurry, and you can't identify any features.
Well, there's video of her in 2 locations using the stolen debit card, correct?
Not Ms. Hart. Ms. Hart is not seen using the stolen debit card. She is present when the stolen debit card is being used. But again, this was 90 minutes after the actual crimes were committed, and just being present when a stolen credit card is being used or debit card isn't a crime. And 90 minutes elapsed between these incidents. So even if we accept Ms. Hart was at the CVS and Citgo, that doesn't establish her presence at the actual crimes.
But you're saying blurry surveillance video of her getting in and out of the car at the time of the crime. And then there's evidence of her 90 minutes later using the stolen credit card, correct?
Correct.
And you're saying that no jury could find all that information to be sufficient?
No, I'm not saying that no jury could. I'm saying that is one inference, but there's just as reasonable of an inference of innocence, which is that she got into the car between the incidents and the CVS and Citgo footage. There were 90 minutes. They left Manhattan. They went to...
Okay, but that would... All right, thank you.
Thank you.
Go ahead, counsel.
Thank you, and good afternoon. May it please the court, Stephen Kress on behalf of the people. So I actually think it makes sense to start at the end in this case and start with the CVS video, which I do want to point out in response to Justice Rosato's question. The CVS video at 6:33 a.m., the timestamp, shows the defendant, not the other woman with her, although she was also swiping the card, but the defendant herself swiping what we now know was Eva Brandenburg's debit card at the CVS.
So it was her.
So yes, the defendant herself can be seen on the video swiping the card. And I think that in and of itself, I think shows that she's not an innocent bystander who has just happened to be picked up somewhere along the road between Manhattan.
But that's a difference, that doesn't prove the robbery, right?
I
Using
think
the
it's,
credit card, it's one of many. So how do you connect, what's the sufficient connection? Obviously that plus what connects?
So one thing that I think is important that my adversary didn't mention is that we know, and this was conceded by the defense, this is page 949 of the transcript, that the defendant is in a relationship with Robin, or had a romantic involvement with Robin Hamilton. It is undeniable, undisputable that Robin Hamilton committed both of these robberies. She is on the surveillance video outside of Ms. Tomaszew's building, and she is on the surveillance video outside of the ATM where Ava Brandenburg withdraws the $60. So what are the odds that a woman who happens to look very, very similar to the defendant just happened to be in the same spots as her girlfriend, or as the defendant's girlfriend, and it was not the defendant? I think the answer is the person who looks like the defendant.
All you're saying is that a reasonable jury could have concluded, based on the video of her getting in and out of the car at the time, and the subsequent videos, and her admission that they were in a relationship cumulatively, that would lead to enough to convict.
That's correct. If you look at everything as a whole, I would agree. If you looked purely at the Tomashev video by itself and only her testimony, you couldn't say, yes, the person in that video is Sharonda Hart. It's when you look at everything else, the fact that she's in a relationship, the fact that it's the same Chevy Malibu that appears in the videos, and then we get a clearer view at the Citgo and the CVS where Brandenburg's debit card is used. It's all of those things taken together that I would say it's actually the only real reasonable
The idea
inference.
that she just happened to get into the car in between becomes too far a trip to take in terms of upsetting this verdict.
Yes, I agree. And I also would say I don't think the time period is even an hour and a half, because I think we know Brandenburg says she's let out sometime after the sun has risen. And they get to the Citgo at, I think, at about 6:30. They had a separate transaction in Manhattan at an ATM on 3rd Avenue at 6:11 a.m. So I think it's at most maybe about an hour. But again, yes, the idea that they just happened to pick up someone who looks very similar to the defendant and then give her a debit card that was stolen and she's seen using it later, I think it's very hard to believe.
All right, but, I was going to turn to the other issue, but if you have more questions on the sufficiency of...
No, I was going to raise something else, but...
Go ahead.
Oh, okay. Much was made of the 2013 photos,
right,
in their brief, and my understanding and make it clear for me on this record, the 2000 photo array of the 2013 that was unsealed, arrest that was unsealed, which helped with identification. Was there any objection to its admissibility?
No, not at the trial itself. When the exhibit was introduced, no, the defendant didn't object at that point. And I will also point out, I have, you probably see it actually over here on the desk. This is the arrest photo that was unsealed. A photo from Robin Hamilton's cell phone of the defendant, which very clearly shows her face, was also admitted at trial, also referenced by the prosecutor in summation. And you can see exactly what she looks like. And that photo was taken, I think, just a couple of days before the robberies in this case. So the jury could look at that photo, look at the defendant, and see that it's her. And I will also point out, I know the defense would say, well, no witness identified the woman in that photo from Robin Hamilton's cell phone as the defendant. They didn't need to. The jury could look at it, look at the defendant, and make the conclusion itself. But also, as I said, the defense conceded she was in a relationship or had a romantic relationship with Robin Hamilton, and the only evidence of that were these photos from the cell phone.
Counsel, was there an improper identification by the two police witnesses?
No, none of those. Neither detective said the person in these videos is Sharonda Hart. And to the extent that it would have been improper for them to be making comparisons and even saying this person's consistent in appearance with the others, again, the jury can look at that themselves. They were instructed a number of times by the judge. It's your job to make that determination, which they could easily do. And if there are no other questions, we ask that the judgment be affirmed.
Thank you. Counsel, you have 2 minutes.
So turning first to the unsealing issue, counsel represented that no objections were made at trial. There were, however, this issue was raised multiple times before trial. It was raised initially in a motion for renewal and re-argument for dismissal in their brief at pages 9 through 12. The court denied that motion. It was then raised again during the suppression hearing, which is in the suppression hearing transcript at pages 111 through 112, and the court told the defense, we're not going to relitigate that. And then again, shortly before voir dire, prosecution sought an in limine ruling to have these photos be deemed admissible, and defense again objected and said they were improperly unsealed. And the court cut off counsel at that point and said they would not entertain argument on whether these were admissible or whether they had been improperly unsealed. And so at that point, counsel had been admonished this was not going to be relitigated. They were admissible. They had no
What's the
obligation to
penalty
further
if they were improperly unsealed?
I'm sorry, what was the question?
What is the penalty on the people if they were improperly unsealed?
Well, in this case, because they were used for identification in a case where identification is the key issue, and the prosecution had very little evidence otherwise of what Ms. Hart looked like, the use of the arrest photos was determinative of her guilt. And so the remedy is either overturning the conviction or, in the alternative, a new trial with those photos suppressed.
Who testified? Who are you saying testified that she was the person? Who testified? Are you saying that the police officers testified that the person in the photo was the person who committed the crimes?
I'm not sure I understand the question.
I don't understand what you're saying is the issue with the photos being introduced.
Right, so the photos were the only photos that the prosecution pointed to as clearly portraying Ms. Hart at the time of these crimes.
Which photos, please?
The arrest photos that were improperly unsealed. Counsel pointed to the cell phone photos. However, as they pointed out, no one testified that was Ms. Hart, and they were not nearly as clear as the arrest photos. Trial took place 5 years later, so these photos were the photos that the prosecution used and told the jury, take these photos, compare them to the videos, that's how you know it's Ms. Hart. The prosecution admitted they were crucial to their case. And because of that, the remedy here has to be an overturning of her conviction or, in the alternative, suppression at a new trial.
Okay, thanks very much, counsel. Thank you, counsel. Will of Michael Milbound.
Good afternoon, Your Honors. My name is Joseph Gruner. I'm the attorney for the appellant, who is the son of the decedent. May it please the court, the case that controls is the Court of Appeals case from 40 years ago, matter of Comstar, and I quote, "It is the indisputable rule in a will contest that the proponent has the burden of proving that the testator possessed testamentary capacity, and the court must look to the following factors. Number one, whether she understood the nature and consequences of executing a will. We'll concede that the testator knew that. Number two, whether she knew the nature and extent of the property she was disposing of. Based on no evidence, no one knew what the decedent owned at the time he signed this will. He didn't discuss his assets with the drafting attorney.
It's not in the notes, but didn't Attorney Rafin say that it's his practice to discuss the assets with the person for whom he's drawing up a will?
Say that again, I'm sorry?
Didn't Rafin testify that while his notes didn't reflect the assets, it's his practice to discuss assets with someone who comes to him for estate planning?
It might be his practice, but I don't think he followed his practice here because he indicated in his notes that the decedent, the testator, was worth less than $100,000, and he got that impression not by asking the decedent, but by looking at him.
Wasn't that the assets that the decedent possessed with his wife?
They didn't discuss what he possessed with his wife. He didn't ask whether the apartment that the decedent was living in, the testator, was owned or rented. He didn't
You don't
ask,
know that, do you?
Excuse me?
You don't know that. You're just claiming that.
No, that's what he said. He didn't ask. There's no notes. And when he said it was worth the assets less than $100,000, we have a co-op apartment on the east side that was worth over $500,000.
No, he testified that Ruffin testified that decedent had an apartment and some accounts, right?
And some,
Accounts.
but he didn't ask him what accounts. He didn't get any
We don't know that.
particulars.
It's not in his notes. Doesn't mean that he didn't discuss it.
He didn't recall any of that information on direct examination.
But
at the
counsel, how does,
1404 hearing.
counsel, how does that bear on testamentary capacity?
Excuse me?
How does that bear on testamentary capacity? The issue of the
statute,
question.
not the statute, the case clearly holds that you have to know what you have and what you're disposing of. He didn't ask the testator what he was disposing of. They didn't discuss it. He assumed...
No, that's not what the testimony was. He said, it is my practice to ask about the assets, and I recall that this person had an apartment and some accounts.
But he didn't say...
There's no requirement that you list.
No, I'm not asking... But as an attorney, when I had...
That's enough. What do you have?
I want to know how much they have.
I don't think that that's correct.
I
don't
think,
that that's
counsel,
required.
would it be accurate, counsel,
number three-
counsel,
One second, I think-
over
Whether he
here,
knew the
counsel,
nature-
I think
Sorry.
Judge
Okay.
Gonzalez has a question.
would it be accurate, would it be fair to say that the real issue here is the fact that the decedent did not acknowledge that he had biological children, specifically his son, and the fact that this son did not receive anything but rather the nephew? Is that the pivotal, is that the crux of the case?
No, the crux is that the testator told the interviewing drafting attorney that he had no children.
Well,
he specifically asked the question, and he was told, I have no children. There was no reason...
He had no
the testator
children
to
with
have
his
lied.
current wife. Isn't it that he had no children with his current wife?
No, he said he had no children, specifically.
In his mind, in that context, he could have been thinking that. We don't know.
He might have been thinking that, but he had a relationship with his son. They spoke.
No, he had no relationship with his son.
If you read what my client testified to, they didn't have a close, loving relationship. And the fact that a son and a father don't have a close relationship is not the end of the world, but they still spoke, and he did give him his Masonic ring a few months after he signed his will. Now that clearly indicates that at that time he knew he had a son, but when he told the draftsman, I have no children, that goes to the heart of the issue of knowing who the natural objects of your bounty are.
Okay, thank you, counsel.
Thank you.
Good afternoon, Your Honors. May it please the Court. Angelo Grasso from Greenfield, Stein & Sr. for the respondent and the proponent, Stephen Milbound. For the reasons that are set forth in our papers, Judge Mayer's decision was well-reasoned and should be upheld. This is
Well, you start with, you have two people who saw him execute the will, right? And they testify, when we saw him execute the will, he understood, he knew what was going on. They're the only people who actually have any personal knowledge, correct?
But it's three people technically, Your Honor?
And the person
drafter.
and the lawyer.
Right, there's a supervising
And they
attorney.
all testified to the same thing.
Correct, Your
He
Honor.
knew he knew what was going on, he had testamentary capacity.
Correct, Your Honor.
There's no question that they were, no question. They submitted the affidavits at the time, and they spoke later, correct? So we start with that presumption.
Correct, Your Honor.
And that will was executed more than 6 years before he passed away.
That's precisely your point, Judge, and I wanted to reiterate that this is, in our opinion, grasping at straws. This is a will that was done 6 years before he passed away. He had a conversation with the attorney drafter. He had a conversation with that drafter a year later where he discussed other items with his assets and with his wife's care. And Mr. Rafan said pretty clearly he had all his marbles about him. He was perfectly fine. The attorney who supervised will execution recalled going over the will with him, and he said the will evidences what he wanted, and even told a couple of stories about my client there. And while the attesting witnesses don't remember a will execution that happened 13 years ago, and I can't blame them, the self-proving affidavit signed contemporaneously with the will execution clearly states that he had capacity. And one of the two witnesses testified at her 1404 examination. She wouldn't state as an attesting witness and sign that affidavit if she had any concerns about his capacity at the end of the day. Quite frankly, the briefs argue that this is all based on presumptions. And yes, a person is presumed to have capacity. It is presumed that a person can execute a will. But there's much more evidence than that in this case, Your Honors. And this, quite frankly, is a case of grasping at straws based on a very minor inconsistency, as Judge May had noted in her opinion, regarding one offhand comment that was made regarding a son with whom he had a very difficult and attenuated relationship,
So
which,
I'd
as
like
Judge...
to explore that a little bit because perhaps for me that's the most pertinent issue. So if we look at a matter of Hurlbut, which is from 1900, the natural objects of a testator's bounty are those who have been closest and dearest to him during his life and from whom he has received the most attention and affection. Apparently, that was not the biological son, painful as it may be to say it publicly and out loud. Also, matter of Timer, 23, Third Department, the failure to expressly disinherit and object it does not undermine a decedent's testamentary capacity. Nonetheless, to the extent, as your opponent says, to the extent that that the decedent did in fact have two children, how does that figure in your calculations?
And I appreciate the question, Your Honor. A couple of points on that. One is that the person with whom the decedent was clearly closest to is my client, his nephew, Stephen. And our brief in the record is ample citation as to why they had such a tight relationship. Second, as I think it was Justice Friedman noted a few moments ago, the children were not his biologically with the wife that he had at the moment. One was adopted from a prior marriage, and one was a child with a prior wife. So it's a very reasonable interpretation that he took that to mean, do you have any children with this wife? Which the answer is no. But third, as I noted, I hate to say someone would say that so-and-so is dead to me, because he didn't say that. But clearly this was a relationship with his son, which was not a great relationship. They spoke only sporadically. He clearly had a very big difference of opinion with his son over his choices in life, such as marrying outside of his faith, such as political differences with them, which don't need to get explored to at this point. But that's how he deemed that the person who was really his heirs was his nephew at the end of the day. And if there's nothing further, judges, I'll rest on my briefs, and thank you very much.
Perfect timing. Counsel?
The fact that the testator specifically disinherited a niece and nephew and didn't disinherit his son, who he should have known would be a distributee if he realized what he was doing, and all the evidence is circumstantial. The fact that he rode a bicycle, he took care of himself, we don't know if he...
No, it's not circumstantial. There's direct evidence. At the time he executed the will, he had testamentary capacity.
No, he had capacity, not testamentary capacity. If he didn't know that he had children...
Are there two witnesses who signed an affidavit saying that he had testamentary
No, they said he
capacity?
had capacity. If he wasn't a raving lunatic at the time he signed it, we don't know if he filed tax returns. We don't know what his income was. We don't know anything because he didn't even discuss his children or his assets with the proponent. The proponent testified that he had no idea, and he didn't even know that his uncle owned the co-op apartment that he was living in until he died.
Did his
That
son know?
tells you something.
Counsel, did his son know that he had an apartment?
Excuse me?
Did his son know that he had an
Yes.
apartment?
The note's silence on a subject does not yet mean that in fact the subject wasn't discussed. It's something which is ambiguous. We don't have evidence on the subject, but it doesn't mean that the opposite of what's not in the notes is true.
But we still have the statement in Comstar that the burden of proof is on the proponent, and to say that they met...
No, and they can meet their burden by those two affidavits. There's tons of
But
cases that say
spend
that. So now
10
it's your,
minutes.
1 second,
They
it's
spend-
your opposition, it's your obligation now to raise an issue of fact, because they've met their burden. They put in those two affidavits, and the case law is clear. Now, how have you met your burden? By saying, well,
No,
this
by-
ambiguous thing
by the
in his
fa-
notes raises an issue of fact?
No, by the fact that he told the draftsman he had no children.
All right, thank you. I think our last case for argument is People versus Vamula.
Last but not least, good afternoon. May it please the court. Legal Aid Society by Everett Hopkins for Mr. Vamula.
I'm sorry, I can't hear you. Can you start again? You got to speak right in.
Sure. Last but not least, Legal Aid Society by Everett Hopkins for Mr. Vamula. Good afternoon, Your Honors.
Good afternoon.
This court should reduce Mr. Vamula sentence because his mental health issues, as well as his substance abuse issues, and as well as his sincere remorse and minimal contact with the criminal justice system.
Well, let's start with
His mental
remorse. No. Yeah, his remorse.
Sure. Well, I didn't plan to go too much into the remorse. I think his statement at sentencing speaks for itself, but he displayed extreme remorse directly to the complainant about the trauma he had caused and how he was sincerely sorry about what he had did, which affected her life greatly.
Counsel, didn't he say at his probation interview that he pushed this person onto the train because he wanted to do time in jail? So, quote, I can aid in reforming the criminal justice system. I am regretful of the pain I caused this individual, but I look at it as perspective of pain and suffering others have while incarcerated. I am willing to sacrifice this one person for the millions of persons who are incarcerated. I wanted to see what jail is and better reform jail. I found out later she was a Latina woman from the Bronx. This has affected me in that it has propelled my career as an activist. Oh my.
He did say all of that, Your Honors, which will turn to his mental health issues. So his...
Well, wasn't the original recommendation 15 years and everyone took into account his mental health issues
correct.
and reduced it down to 8 years?
Correct, the people did do that.
Okay.
Because his top count was an attempted second-degree murder,
Correct, Your Honors.
and he got 8 years.
Correct, he did. And so we're asking for a reduction here because it's still a mitigating factor of his mental health.
Well, it was taken into account significantly,
Well,
significantly by the trial court. It wasn't reduced
Sure.
by a year, it was reduced in half, basically.
Sure, Your Honors, no one's denying that, but that's not the standard for finding a sentence excessive, as the Court of Appeals has held in Brisbane.
I think also the people
Bar.
challenge, do they not, the extent of the mental health issues, that the diagnosis is not as extensive as the defendant argues on appeal.
Well, I don't want to compare mental health issues just because someone's not, suffering from psychosis or having hallucinations doesn't mean that their issues aren't, severe.
But didn't your client say that he pretended to commit suicide and
That's what he said.
regarding to the one prior psychiatric hospitalization?
It was a very real suicide attempt. What happened is that his parents had approached him about his marijuana addiction, and instead of being able to have a conversation, his disproportionate, impulsive emotional response, which is part of his mental health issue, he decided to slit his wrist in front of his parents. So that's what happened, right? And so we've seen instances and examples of this disproportionate response, which is literally the definition of mood and adjustment disorder. At the age of 7, his father recalls him having having breakdowns over small issues like dropping a pencil on the floor, right? That's, as a 7-year-old, that's not normal behavior. At 13, in his teenage years, now,
At the time he was arrested, was he receiving mental health services?
no, he was not for several years.
And he was not on medication either,
He was
correct?
not on medication.
And he was not diagnosed with a mental illness.
He was diagnosed a couple of years before, but what happens is he gets released, he doesn't keep up with outpatient treatment, he relapses, and the cycle continues. So he needs long-term treatment, some type of residential treatment, so that he needs some type of psychotherapy so he can identify his stressors, learn proper coping mechanisms. But these are all things,
he has to agree to that, right? We can't force that on him.
Of course, Your Honor,
Right.
but
And has he ever agreed to that before?
well, no, but
He has
also his
he has a long criminal history, correct? And he had outstanding warrants even at the time he was
He only has
arrested.
one conviction, Your Honor, from Missouri. I believe it's just for a misdemeanor. But also, his family really didn't support him in getting the help that he needed. They
There's
just kinda-
warrants in Florida and Michigan also?
He did at one time. I'm not sure if they're active, but he did at one time.
They were active at the time of his arrest.
Didn't his family send him to India in the hope of giving him special care?
They did. They sent him to India after, I think in around 2018, and he was there for about 2 months. Now, they tricked him into going to India so that he can get help. Of course, he wasn't too happy about that. But, he came back after those 2 months, and once again, the cycle continued. He needs some type of long-term treatment.
Which we can't force on him.
No, but you can help him get the treatment he needs sooner rather than later.
Thank you.
Your Honor,
Go ahead.
good afternoon, Your Honors, and may it please the court. Russell Spivak for the people. Defendant tried to kill an innocent woman by pushing her in front of an oncoming subway, right as the car.
It's a miracle. How did she survive? I was amazed at that.
The people described it as sheer luck. I think that is accurate. As far as we understand it, she fell in between the subway tracks. So absolutely, it is certainly a miracle.
And prior to saying that he did it because he wanted to be in prison to assist, he said that he did it because she robbed him or she took something from him, right?
That's correct, Your Honor. The defendant had, his initial statement was the victim, the complainant.
That you took his bag?
Yeah.
Correct. We believe it might have been the night before, and she may or may not have looked like that individual.
Counsel, how do you deal with the concern raised by your opponent to the extent that the defendant is in need of mental health treatment and would greatly benefit from such? I mean, is that a factor that we can consider or should consider by way of reducing his sentence, which your opponent deems excessive?
Your Honor, I think there are a few different ways to respond, and each of them are grounded in the record. The first is the point that Your Honors had made previously, which is the defendant's family did provide exceptional support, sending him to treatment. Yes, it may have been under potentially a false pretense, but in my view and in the people's view, that's absolutely family support. They also did the same thing after the purported suicide attempt by sending him to, I believe it was the Ford Clinic back home in Michigan. As we understand it, compared to many of the defendants that may well come before you and your colleagues, that's a family that is really trying to do right by the defendant. It also speaks to one of the points that was made earlier about a plan. So
I'm sorry, about
a plan, a treatment plan. So as Your Honor had said, it is absolutely the case that we can't force the defendant to move forward with a treatment plan. And so far on the record, we're not aware of any potential plans moving forward when, if this was the family support that the defendant already received and we ended up here anyway.
Counsel, weren't the alleged mental health struggles taken into account when
Yes,
you
Your Honor.
fashioned out this plea arrangement?
Yes, Your Honor, they were.
The exposure was 25, right?
Correct, Your Honor.
The demand was 15 and he got 8.
Correct. The initial opening offer at arraignment was 15. That's right, Your Honor.
Is there any circumstance under which the defendant could be forced or required to undergo mental health treatment as a condition of release?
I'm not aware of that, Your Honor.
I'm not either. That's why I'm asking you.
No, it's a great question. I'm not aware of any conditions that would be made. That might have to be a motion back to the sentencing court, but at least on the record before us.
That's the point. At sentencing, historically, they could have considered options. For example, there's Oasis for someone who drinks and drives. I mean, we have many programs, et cetera, like that. But under these circumstances, we can't do anything about it.
Correct, Your Honor. Unless everyone has other further questions, the people would ask that we affirm.
Thank you. You have 2 minutes, counsel.
Can I ask you the same question, counsel, please?
Sure.
Are there any circumstances of which you are aware which would require the defendant to undergo mental health treatment?
Not at this point, Your Honor.
There's nothing now, right?
Not at this point. I'm not aware. There may be, but I'm not aware. But what I would say
Well, he
is
wasn't sentenced to anything like that.
That's what I was
right?
going to say. I mean,
And so if he leaves at 5 years, it's not us saying, we can't say to him, you can leave after 5 years if you go into residential treatment. It's 5 years, and then he does what he does, right?
right. I mean, he's going to be released anyway, right? Do we want
At
him-
some point.
At some point, he's going to be released, whether it would have been 25 years or whether it's going to be
Is
5.
he compliant with his medication while he's serving his sentence?
It's unclear, Your Honor. I'm not
Is he
sure.
on medication?
I'm not sure. I'm not sure. So, I mean, look, he does have a long way to go, but he is, around 30 years old, so he's still relatively young. The one thing I do want to point out is that, I brought up his mental health having an impact because, after he had left Detroit, he had been to Illinois, Missouri, Florida, and when he got to New York, he had been incarcerated a couple of times. He does have some warrants outstanding, I believe. And he had, spoken to people who he perceived and they all perceived as, being unjustly incarcerated, suffering from oppression. He says he carried that pain with him. And again, tying it back to when, he had this emotional response when he dropped his pencil, he carried these emotions for several years when he, engaged in his conduct here. So that's his disproportionate response, right, to certain pain that he perceives. And that's why he needs to have treatment.
No, I don't think any of us dispute that he needs treatment. The only question is whether reducing his sentence for 5 years is a guarantee that he's going to get the treatment. And I think you've said there's no way for us to make sure that that happens.
There's also no guarantee that he's going to get it while he remains incarcerated. I mean, and just lastly, he does show promise of improving. He majored in neuroscience, and he did that for 3 years until, his mental health caught up with him. So
Did he, may I?
Yeah.
Did he, did anyone consider offering a plea of guilty by reason of mental defect or illness?
Not that I'm aware. I think the only thing defense counsel was trying to do was get him into some type of mental health program, which
I know people don't want to take that kind of plea because in you go into the psych hospital.
Yeah, it's right, correct. But I think they were trying to get him into some type of program which the people wouldn't go along with.
Thank you very much, counsel. Thank you, counsel. Thank you.
Have a good night. Take care, Russell. Great meeting you.
Likewise.
All right, get home safe.